Okay. So our subject, as you may all know, is criminal procedure. And I want you to take note that in the application of criminal procedure, or the application of criminal procedure happens when there is a prior commission of a crime, or that at least there is a perception that a crime has been committed. As you can see on the screen, I created here a graph of what the entire criminal procedure looks like. Okay, so as an introduction, I will walk you through the process from the commission of the crime down to the preliminary investigation, to the filing of the information, to the arrest, if there is not yet an arrest without a warrant, to the arraignment, to the pre-trial, to the trial, and then to the judgment, and then later on, appeal, as well as the service of sentence. Okay? Again, I want you to take note that this subject, criminal procedure, happens, or the application of this subject only happens when there is a prior commission of a crime, or at least the perception that a crime has been committed. Yesterday, you've had your criminal law, and I'm sure you've already defined what a crime is, what a felony is, di ba? When we talk about a felony, these are acts or omissions punishable under the revised penal code. Na po tayo gitawag nga mga offenses punishable by the special penal laws. Okay? Collectively, they're called crimes. Okay? So kung walay krimen nga nahitabo, you will not find application aning criminal procedure. Okay? This is because there can be no criminal action unless a crime is believed to have been committed. Remember that that is the starting point of criminal procedure, the commission of the crime. Okay? Now, I want you to look at this graph in three categories. Makita naman siguro, no? I'm sure gagmay siya, but if you zoom it in, maklaro naman ang mga words in the boxes no, found in the graph. Ang mga crimes, guys, nga na-commit, which is the starting point, it could be that under the law, there could be a requirement of a preliminary investigation. Okay, preliminary investigation. Naapoy krimen nga wala nag-require under the law of preliminary investigation. Okay? Naapoy mga crimes nga committed in flagrante delicto. Okay? I want you to look at the criminal procedure in that category. To look a category. Ang crimes wherein the rules require that there be a preliminary investigation. Ikaduha, crimes wherein the rules require that there be no preliminary investigation. Og doon na po'y crimes committed in flagrante delicto, or kana bitawng you are caught in the act of committing a crime or an offense. Okay? So maone nga ato ni siyang tagsa-tagsaon, okay? So what is the process di ay, attorney, if you commit a crime and that particular crime requires a preliminary investigation? Unsa may rule nga mo apply, unsa may process nga mahitabo? By the way, kay baw mo og unsa ang mga crimes which actually require the conduct of a preliminary investigation? In your readings, have you gone through it? Unsa man ang mga crimes that require the conduct of preliminary investigation? Anyone?
Yes, attorney.
Unsa man?
Yes,
Those crimes with an impossible penalty with more than 4 years, 4 years, 2 months, and 1 day.
Okay. Ang key ana is 4 to 1, okay? If the imposable penalty under the law is 4 years, 2 months, and 1 day, the rule states that kailangan mag-conduct og preliminary investigation, okay? Now, what happens during the preliminary investigation? What should be found out man in a preliminary investigation? Ang preliminary investigation is actually the determination, okay? This is a determination whether or not probable cause for the purpose, or whether or not there is probable cause for the purpose of filing an information. Okay? Ang pangitaon during the preliminary investigation is to determine whether or not there is probable cause for the purpose of filing an information. So, okay, if naay unsa may mahitabo kanus aman makahibaw si isa may mukandak sa preliminary investigation. In your readings, I'm sure you've read in passing nga ang mukandak sa preliminary investigation kay si prosecutor, di ba? This is done by filing a complaint before the prosecutor's office, and then the prosecutor's office will issue a subpoena to the respondent, the person who allegedly committed the crime, asking him to file his counter affidavit. Okay? So kung ma-receive na ni fiscal or ni prosecutor ang complaint as well as the counter affidavit, the prosecutor will now determine if there is probable cause to file an information before the court. Okay? Kung si prosecutor finds that there is probable cause, he or she will now resort to the filing of an information. Asa man i-file ang information? Adto sa korte, okay? Sa proper court. Either it could be in MTC, it could be in an RTC, okay? So, kung sa may tabo, kung nanay information nga gi-file sa court, syempre, na naman na kang judge no, na naman na sa court. So, the court will now determine again if there is probable cause. But this time around, ang tanawon niya or ang purpose for determining probable cause is whether or not to issue a warrant of arrest. Okay? So, from the prosecutor's office, the determination in the prosecutor's office of probable cause, whether or not there's probable cause, kay ang purpose ana is to file an information. But if there is probable cause, the prosecutor will now file the information asa man ngadto sa korte. Og na nasa siya sa korte, ang judge na pud karon mo tan-aw na pod if there is probable cause. But the purpose for which to determine probable cause is no longer to file an information because there's already an information, but for the issuance of a warrant of arrest. Now, going back ngadto sa prosecutor's office, suppose the prosecutor finds that there is no probable cause. Unsa may mahitabo, si prosecutor can always dismiss the case. Okay? The same is true if the prosecutor finds the information in court and the court finds that there is no probable cause. Ngayon siya, sayop man si fiscal, sayop man si prosecutor, wala may probable cause ani. The court can always dismiss the case and that will be the end of it. Okay? Pero, kung ang court finds probable cause to issue the warrant of arrest, what will happen? Of course, mo-issue siya og warrant of arrest and there will be an arrest on the person charged or on the part of the accused. Nganong necessary man guys ang issuance of the warrant of arrest? Nganong necessary ang issuance sa warrant of arrest? Because this will be the starting point over which the court can actually acquire jurisdiction over the person of the accused. Okay? So kung ma-acquire, kanus ang ma-acquire ang person over the accused, that's upon the arrest of the said person or upon its voluntary surrender before the court, which you will find out later on. Okay? So suppose, going back to this atong graph, suppose there's already an issuance of a warrant of arrest and the accused is already arrested. What happens next? What happens is the arraignment. Okay, arraignment. Unsa maning arraignment? Diri sa arraignment, ang akusado will be informed of the nature and the cause of the accusation against him in order to comply with the constitutional requirement that the accused should be informed of the nature and cause of the accusation against him. Unsay paagi ana? Nana siya sa korte, basahan siya. O ikaw, Juan de la Cruz, ipasakaan ka sa kaso nga rape ni adtong so on and so forth. How do you plead? Okay? So diri siya musulti kung guilty ba siya or not guilty. Okay? Kung plea siya guilty, of course, the court will now render the appropriate penalty. Kung moingon siya not guilty, it will proceed to pre-trial. But remember also that during the arraignment, there could be other procedural incidents that may happen. Okay? Pwede nga in this instance, si accused may file a motion to quash the information. Okay? So may mga instances na apod ni siya sa rules later on atong sa on, but example ani motion to quash is if the allegations in the information do not charge any crime, or ang gisulti dito sa information does not necessarily fall within the definition of a crime. So pwede na niya nga erase during the arraignment. Okay? If the court finds that the motion to quash is sufficient, pwedeng ma-dismiss ang kaso. But if the court finds that the motion to quash is insufficient, mo proceed na sa arraignment. Okay? So going back sa arraignment, after niingon si akusado nga not guilty siya, what happens next is the pre-trial. Okay? Pre-trial. In the pre-trial, diri mahitabo ang mga stipulation of facts, diri mo mga admissions, diri nimo isulti kung unsay mo mga ebidensya, diri nimo isulti kinsa imong mga testigo, and diri sad mahitabo ang pagset sa mga trial dates. Okay? In the pre-trial. That's before the trial. That's why we call it pre-trial. After the pre-trial, we have now the trial proper. In the trial proper, diri mahitabo ang presentation of the prosecution evidence, and then after the prosecution presents its evidence, sunod dayon ang ebidensya sa depensa or sa defense, or the defense on the part of the accused. Okay? After that, the court will now render judgment. Okay? Judgment. If the judgment is unfavorable, if unfavorable on the part of the accused, meaning convicted siya, ang iyahang remedy is to file an appeal. Okay? Mo file siya og appeal sa appropriate court. But if the judgment is an acquittal, the prosecution in this case can no longer file an appeal. Okay? Sa appeal, ang maka-file ani is si accused if unfavorable ang judgment sa iyaha. Okay? Now, if final and executory na ang decision sa korte, ang sunod nga mahitabo ana is now the service of the sentence. Mo nang mapriso na siya og serbisyoan na niya ang sentensya nga gihatag sa korte sa iyaha. Okay? So basically, that's the overview, or that's the process when a crime committed requires the conduct of a preliminary investigation. Okay? Now, unsa may process, attorney, if the preliminary investigation is not necessary? What are the instances wherein preliminary investigation is not necessary? It is not necessary when the imposable penalty does not exceed 4 years, 2 months, and 1 day. Okay? Meaning, kung paubos ana, walay kinahanglan nga i-conduct ang nga preliminary investigation. But you also have to make a distinction. Kay bisan pa o ubos pa na ang imposable penalty to 4-1 or 4 years, 2 months, and 1 day, if the crime is committed in a chartered city, lahi iyang process, okay? To that of a crime committed in a province, okay? Anong lahi man? Kay when a crime is committed in a chartered city like that of Cebu City, and the crime does not require preliminary investigation, ang process ana would be to file a complaint still before the prosecutor's office. Okay? Dili diretso sa court. Kay ideally yunta, if there's no need for the conduct of preliminary investigation, ang complaint supposedly should be filed directly to the court. But if the crime is committed in a chartered city, gi-qualify na siya sa rules, okay? Ningunang rules, you need to file the complaint before the prosecutor's office. Okay? But the prosecutor's office here would not conduct the usual preliminary investigation. Nga katong padadaan og subpina si akusado para o si respondent pa siya ani ha kung wa pa siya naabot sa court, si respondent aron maka-file siya siyang counter affidavit. What the prosecutor in this instance will do is just to determine probable cause based on the complaint and the evidence presented by the complainant. Okay? So kung unsa ra gi-file sa complainant kang fiscal or kang prosecutor, maura na iyang tan-aon, maura na iyang i-review, maura na iyang basihan sa iyang determination of probable cause. If the prosecutor finds that there is probable cause, balik ka sa process, there will be a filing of the information in court, and then upon the filing of the information in court, the judge will either issue a warrant of arrest or will issue a warrant of arrest, and then after the person or jurisdiction over the person of the accused is acquired by the court, mo proceed yun sa arraignment. The same is true sa kung giingon ganihan that there could be motion to quash that may be filed by the accused in this instance, and then if it is not sufficient, it will proceed with the arraignment. Not if the plea of the accused is not guilty, it will proceed to pre-trial and then trial, over which there's a presentation of the prosecution evidence and the prosecution or the presentation of the defense evidence, and then afterwards the judgment, and then if unfavorable na po ang judgment on the part of the accused, mo apilar siya, and then if final and executory na ang judgment, there will be a service of sentence. Okay? Now, if the crime does not require for the conduct of a preliminary investigation and it is committed in a province, lahi ang process ana as opposed to the chartered city. Okay? What happens here is that kung ni-commit ka og crime in a province and the imposable penalty of the crime that you committed does not exceed 4 to 1 or 4 years, 2 months, and 1 day, ang imong buhaton as a private complainant is to directly file a complaint or information to the court. Okay? Diretso na sa korte og file. If the court determines that there is probable cause, okay? If the court determines that there is probable cause, the court will now again issue warrant of arrest. Yeah. So on and so forth na pod ang iyang process until judgment is rendered, and then the service of sentence follows. Okay? Now, mao to ang ikaduha nga category. First, unsa to, if the crime requires that there be a conduct of preliminary investigation. Ikaduha, if the crime committed requires that there be no conduct of preliminary investigation. And the third one is kaning ato i-discuss karon, which is if you commit a crime in flagrante delicto, or you are caught in the act of committing a crime. Okay? So unsa may process ani, it will start with the arrest. Okay? Mauning sa may left side, tanawa. It will start with the arrest. Here, the arrest is without a warrant. Walay warrant. Okay? So, the accused here was arrested while in the actual commission of the crime. Okay? In the actual commission of the crime. So, example, ana, nangawat ka, unya naaktuhan ka, gidakop ka, that's caught in flagrante delicto. X killed Y. Unya, before pa siya nakadagan, nasakpan siya sa police, that's caught in flagrante delicto. That you can be arrested even without a warrant of arrest. Okay? Because here the accused was arrested while in the actual commission of the crime. Now, in this category, unsa may mahitabo after the arrest is made? Here, what comes after the arrest is the inquest proceedings. Okay? Inquest proceedings. The inquest proceedings has to be conducted.
I have a question. Sorry. Hello?
Can you please mute your mic? Thank you. Okay. So what comes after the arrest is the inquest proceedings. Okay? The inquest proceedings will be conducted by the inquest prosecutor. Inquest prosecutor. Unsa may mahitabo ana attorney during the inquest sa mga pulis dire, familiar kayo sila aning inquest, okay? Ang mahitabo dire will be the person arrested or the respondent in this case can actually ask for a preliminary investigation or for the conduct of the preliminary investigation. Pero kailangan sila nga mo execute og waiver of Article 125 of the Revised Penal Code, which I'm sure you will discuss later on sa inyong onyang criminal law. But basically, during the inquest, pwede yung mo request si person arrested or si respondent nga pwede mag-PI sa kapiskal. But para dili malapas sa time within which to file a complaint or information, kailangan mo execute og waiver under Article 125 of the Revised Penal Code si respondent or si person arrested. Okay? So supposing kung wala ning ask si respondent or si person arrested for the conduct of the preliminary investigation, then the inquest prosecutor here will only determine if there is probable cause for the filing of an information. Dire, mangutana ra na siya. Okay? Unya, basihan sa niya ang complaint nga gi-file unya sa complainant or sa arresting officers as the case may be, okay? And if there is a probable cause, if the inquest prosecutor finds probable cause, what will he do after? Same process, he will file an information sa court, and if na-file na sa court, what will be the function of the court after receiving the information? Mo-issue pa siya warrant of arrest? Ma-issue pa siya warrant of arrest after the filing of an information by the inquest prosecutor? Anyone?
No, attorney.
No,
No more. Okay, what the court will issue is the commitment order. Yes, the commitment order. Dili na warrant of arrest. Okay? So after ana, schedulean na po siya arraignment, and then so on and so forth. So basically, that's the map or that's the graph or process flow of what criminal procedure looks like. The nitty-gritty of all these rules will be discussed later on in our succeeding discussions. Okay? Now let's go to the basic concepts of criminal procedure. Okay? Let's try to find out what is the ultimate goal of criminal procedure. And I want you to also note that our criminal procedure or our procedure is adversarial or accusatorial in nature. And when it comes to the interpretation of the rules, there has to be liberal interpretation over it. Okay? Now let's start with the ultimate goal of criminal procedure. As you may know, criminal procedure is described as the network of laws and rules which governs the procedural administration of justice. By the way, when we talk about criminal procedure, usa ni siya sa mga category sa remedial law, okay? I'm sure you already know that there are eight bar subjects, diba? 8 bar subjects. We have civil law, we have labor law, we have unahon ako for Sunday, political law, taxation law, civil law, commercial law, we have criminal law, we also have sa ko nakalimutan, taxation, criminal law, legal ethics, we have remedial law. Si remedial law, na siya tagsa-tagsa ka mga sanga. We have the civil procedure, we have evidence, we have special procedure, we have special civil actions, and then we have criminal procedure. Okay, so usa lang ning criminal procedure sa mga subject under remedial law. Okay, criminal procedure treats of the rules and processes by which criminal laws are enforced and by which the state prosecutes persons who violate such laws. Okay? Procedural law, according to the Supreme Court, as applied to criminal law, provides or regulates the steps by which one who committed a crime is to be punished. Okay? Diba sa inyong pagstudio gahapon sa criminal law, we define criminal law as that branch of law which defines crimes, treats of their nature, and provides for their punishment. Okay? While kaning criminal law declares conduct or what conduct is criminal and defines crimes or prescribes punishment for such crimes, kining criminal procedure lays down the processes by which an offender is made to answer for the crime he committed. Okay? Nay crime nga na-commit, let's say murder. Kahibaw ka unsay punishment. Kahibaw ka unsay definition sa murder, di ba? But wa ka kahibaw unsaon nimo siya pag-punish. Diha mo come in ang criminal procedure. Because criminal procedure lays down the processes by which an offender is made to answer for the crime he committed. Okay? Criminal law also confines itself to the definition of offenses, the penalties applicable for such offenses, and the formulation of general principles for liability. It does not, however, answer the question as to how the offender is to be made liable for his crime. Okay? So, for instance, in your revised penal code, particularly in Article 249, sama sa kong giingon ganiha, it defines the crime of homicide. Na apo diha makita nimo ang penalty. The penalty of homicide is reclusion temporal, di ba? But the revised penal code does not prescribe the methods and processes by which the offender is made accountable for the crime of homicide. Wa dito gibutang sa revised penal code nga inanion pagpreso, inanion pagpenalize si akusado, okay? Ang nagsulti ana kung unsaon ang method, unsaon ang process for which the offender is made to be accountable for the crime that he committed are actually found in the rules of criminal procedure. Okay? I want you to take note of that concept. So basically, si criminal law, mao na ang substantive law. Si criminal procedure, mao na ang procedural law. Okay? Now, the enforcement of criminal laws of the state inevitably leads to governmental intrusions into an individual's zones of privacy. Now, you may ask, how can we reconcile these intrusions with the constitutional and statutory doctrines protecting individual rights? According to Riano, in the prosecution for the violation of penal laws, criminal procedure has the imposing task of balancing clashing societal interests, primarily between those of the government and those of the individual. Criminal procedure, therefore, has the ultimate goal of harmonizing the governmental functions of maintaining peace and order and protecting the constitutional rights of its citizens. Okay? Dili lang ang pag-maintenar sa peace and order ang goal sa criminal procedure, but also to protect the constitutional rights of its citizens. Which later on in our study, maka-learn mo nga pwede di ay ma-dismiss ang kaso no if you do not follow the rules of procedure, if you do not follow the constitutional provisions guaranteed to a person accused for the commission of the crime. So basically, ang criminal procedure, dili lang na aron protektaan or imintinar ang peace and order, but also to protect the constitutional rights of the citizens, okay? Now, I also want you to remember the principle that criminal procedure or our procedure here in the Philippines is adversarial or accusatorial in nature, okay? Adversarial or accusatorial in nature. The system of procedure in our jurisdiction is accusatorial or adversarial. It is not inquisitorial, okay? It contends two contending parties before the court, which hears them impartially and renders judgment only after trial, okay? Diri sa atua, adversarial, meaning duha ang parties, dunay prosecution, this is criminal procedure, let's focus on the parties in a criminal procedure, dunay prosecution, dunay defense or accused. Okay? And in this case, kaning duha ka contending parties will appear before the court and will present their case. Okay? And then ang korte will hear them impartially and will then render judgment after the trial. Okay? In our judicial setup, ladies and gentlemen, a judge is not permitted to act as an inquisitor who pursues his own investigation and arrives at his own conclusion on his own. Okay? Diliin ana ang atuang system diri sa atuang nasod. Because ngano to adversarial. Ang parties diha sa iyang atubangan ang mupresentar sa ilang kaso o mupresentar og evidence, and based on the evidence presented by the two parties, the judge will now act upon it after trial. Okay? Unsa may kalahian de ani sa inquisitorial system? Sa inquisitorial system, the court plays a very active role and is not limited to the evidence presented before it. Okay? The court in this case may utilize evidence gathered outside the court, and a judge or a group of judges under this system actively participates in the gathering of facts and evidence instead of passively receiving information or evidence from the parties. Okay? The judge here steers the course of the proceedings by directing and supervising the gathering of the evidence and questioning of the witnesses to the case. Thus here, the counsels in the inquisitorial system have less active roles than they have in an adversarial system. Okay? Let's have a break, so guys, for 5 minutes. 5-minute break. Okay, let's now proceed to the third concept, that the interpretation of the rules is that of liberal interpretation. Okay, the rules on criminal procedure, being parts of the rules of court, shall be liberally construed in order to promote their objective of securing a just and speedy as well as inexpensive disposition of every action and proceeding. Okay? An example or a case over which the liberal construction was demonstrated by the Supreme Court is the case of Cariaga versus People. Okay, Cariaga versus People. In this case, ang counsel ni petitioner Cariaga, in this case, yung former counsel, erroneously appealed her conviction to the Court of Appeals instead of to the Sandiganbayan. So in this case, the petitioner pleaded that the provisions of the rules of court, specifically Rule 50, Section 2, which mandate that the dismissal of cases erroneously appealed to the Court of Appeals be relaxed, and that the Court of Appeals be directed to forward the records of the case to the Sandiganbayan. Okay? In this case, the Supreme Court agreed with the petitioner and granted the prayer of the petitioner. The Supreme Court held that since the appeal involved a criminal case and the possibility of a person being deprived of liberty due to a procedural lapse is great, a relaxation or the liberal construction or interpretation of the rule was warranted. Okay? The Supreme Court in this case emphasized the need to view the rules of procedure as tools to facilitate the attainment of justice, such that any rigid and strict application thereof, which results in technicalities tending to frustrate substantial justice, must always be avoided. Okay, so note of these basic concepts: the ultimate goal of criminal procedure, the adversarial or accusatorial system of criminal procedure, and of course the liberal interpretation of the rules on criminal procedure. Now, when can there be a valid exercise of criminal jurisdiction? Okay, what are the requisites in order for the court to exercise jurisdiction over a particular criminal case? There are 3 requisites. Okay? Na ay tulo ka mga requisito. Una, jurisdiction over the subject matter, jurisdiction over the territory, and jurisdiction over the person of the accused. Dali ra kayo ni pag-remember, guys. STP, okay? Jurisdiction over the subject matter, jurisdiction over the territory, and jurisdiction over the person of the accused. Now, unsa maning jurisdiction over the subject matter? Okay? Jurisdiction over the subject matter refers to the authority of the court to hear and determine a particular criminal case. Okay? In its simple terms, it is called jurisdiction over the offense charge. Okay? Jurisdiction over the offense charge. Now, in one of the cases decided by the Supreme Court from years ago, the Supreme Court described jurisdiction over the subject matter as the authority to hear and try a particular offense and impose the punishment for it, or that the offense is one which the court is by law authorized to take cognizance of. Okay? Kung ato ning layman nga pagka-storya ang jurisdiction over the subject matter, nagpasabot kung unsa man nga korte ang pwedeng mo take cognizance over a particular case. Okay? Let's say a crime punishable or a crime over which the law provides for an imposable penalty of 10 years and 2 months. Unsa man nga jurisdiction or unsa man nga court ang dunay jurisdiction anang kasuha. kung ang imposable penalty is 10 years and 2 months and 1 day, let's say, aha man na ma-fall nga court, which court has jurisdiction over that particular case?
RTC, attorney.
RTC.
Regional Trial Court.
RTC, that's correct. Okay.
Yes.
In your readings, you've already known na kung ang imposable penalty sa usa ka crime does not exceed 6 years, ang naay jurisdiction over that subject matter is the MTC, di ba? Kung ang crime, kung ang imposable penalty over a particular crime exceeds 6 years, ang dunay jurisdiction over the subject matter is the regional trial court. Okay? Later on, you will also learn nga doon na po'y mga krimen nga even if ang imposable penalty does not exceed 6 years, pwede ding ma-fall under the RTC. Okay? Ato nang tagsa-tagsaon later. Now, how is jurisdiction over the subject matter conferred? Okay? How is it conferred? The jurisdiction over the subject matter is conferred by law. Okay? And the lack of it affects the very authority of the court to take cognizance of and to render judgment on the action. Okay? Simply put, kung ang usa ka judgment is rendered void because the court that actually took the case has no jurisdiction, ang kana nga judgment will not be considered a judgment at all and cannot be considered a source of any right nor creator of any obligation. Nga naman, because in the first place, the court who actually took cognizance of the case do not or does not have jurisdiction over the subject matter because nga naman, jurisdiction is conferred by law. Okay? Now, while jurisdiction is conferred by law, the rule is that the allegations in the complaint determine both the nature and the action of the jurisdiction of the court. Okay? Just because you see in the information that the title over it is, let's say, homicide. No, not homicide, but frustrated homicide, for example. Frustrated homicide. But the allegations in the complaint do not actually say that it is frustrated homicide. Let's just say it's less serious physical injuries. And less serious physical injuries fall within the jurisdiction of the MTC. Okay? So, kung moingon ka o jurisdiction is conferred by law, it does not mean you should base your determination of the jurisdiction on the title or on the caption perhaps of the complaint. It has to be based on the allegations in the body of the complaint. Okay? It has to be the cause of action in the complaint is not what the designation of the complaint states, but what the allegations in the body of the complaint define and describe. So basahon gyud nimo ang tibuok nga complaint. If the complaint do not actually say that it is frustrated murder, let's just say it's murder, frustrated murder, but it's actually just less serious physical injuries. So you will now say, oh, the RTC has no jurisdiction. It has to be the MTC that has jurisdiction over this particular case. Okay? Also remember that jurisdiction over the subject matter in a criminal case cannot be conferred upon the court by the accused, either it be by express waiver or otherwise. Okay? Because nga na to, balik na punta, because jurisdiction is conferred by law. It is conferred by the sovereign authority which organized the court and is given only by law in the manner and form prescribed by it. Okay? Also remember that jurisdiction over the subject matter cannot be presumed or implied, but it must appear clearly from the law or it will not be held to exist. Okay? Di sad pwede nga ang jurisdiction over the subject matter may be conferred by the agreement of the parties. Di pwede nga ang akusado o ang complainant magsabot, ato lang ning i-file sa MTC bisag ang jurisdiction is with the RTC. It cannot be done because jurisdiction over the subject matter cannot be conferred by the agreement of the parties. Or it be by the court's acquiescence, okay? Nasayop kag jurisdiction but ang court ni sugot na pod, okay ra. It cannot be, okay? At the end of the day, it will be considered a void judgment by virtue of the lack of jurisdiction over the subject matter. It cannot also be conferred by erroneous belief of the court that it had jurisdiction, or by the waiver of objection, or by the silence of the parties, okay? Also remember that jurisdiction over the subject matter cannot be acquired through a waiver or enlarged by the omission of the parties or conferred by the, as I've mentioned earlier, acquiescence of the court. Okay? Kaya nga no to, mabalik na punta because the jurisdiction over the subject matter is conferred by law. Ang balaod mismo ang nag-ingon nga ang kaning kortiha mauni na ay jurisdiction over this particular case. Okay? Now, unsaon man nato pag-determine ang jurisdiction over the subject matter? As I've mentioned earlier, in order to determine the jurisdiction of the court in a criminal case, the complaint or the information must be examined, okay, for the purpose of ascertaining whether or not the facts set out therein and the punishment provided for by law for such acts fall within the jurisdiction of the court in which the criminal action is filed. Okay? It is settled that the jurisdiction of the court in criminal cases is determined by the allegations in the complaint or information and not by the findings based on the evidence of court after trial. Okay? Based yun na siya sa allegations in the complaint or information. The same is true in criminal cases. Ang jurisdiction will also be determined based on the allegations in the complaint. Okay? So as a conclusion, only the allegations in the complaint or information constitute the guidepost in determining the jurisdiction of the court. Okay? Disregarding the defenses of the accused or whatever evidence is presented during the trial. The basis over which to determine the jurisdiction of the court is solely on the allegations in the complaint or information. I want you to remember that, okay? Also remember, guys, that jurisdiction is not determined by the penalty actually imposed after trial, okay? But the penalty imposable by law on the offense. Kay, di ba, sige, tag-ingon nga, jurisdiction is conferred by law, jurisdiction is conferred by law, and it is based on the allegations of the complaint, so and so. But unsa may gipasabot ani ingkang jurisdiction is conferred by law? The basis of the jurisdiction conferred by law is the imposable penalty. Okay? Imposable penalty. But remember that ang jurisdiction is not determined by the penalty actually imposed after trial, meaning dili ang penalty nga gihatag sa judge after the trial, but by the penalty imposable by the law on the offense. Okay? Kung unsay gisulti, let's say murder, kung unsay gibutang nga penalty sa murder, let's say reclusion perpetua, so that should be the basis of the jurisdiction. Okay, mo na itong giingon nga jurisdiction is determined by law because the law provides that murder is punishable by, example, reclusion perpetua. Okay? So, the determination there is the penalty imposable by law and not the penalty actually imposed after trial. Muna inyong timanan, okay? You have to use the imposable penalty and not the actual penalty imposed after trial. Okay? Therefore, if the allegations of the information charge the accused with an offense within the jurisdiction of the RTC because the imposable penalty exceeds 6 years, the court has jurisdiction even if ang penalty imposed later on by the court after trial is imprisonment of less than 6 years. It could happen because doon na may mga judges nga dili mo follow strictly what is provided for by the law or what is the provided imposable penalty. Okay? So bisan pa og ang actual nga gihatag nga penalty does not exceed 6 years, if the imposable penalty under the law exceeds 6 years, still the jurisdiction in this case is with the RTC. Okay? It should be with the RTC. Now, unsa may balaod nga mo apply to a criminal action, what should be the law or statute that should apply when you institute a criminal action? Okay? In the case of People versus Lagun, the Supreme Court said that it is a settled doctrine that the subject matter jurisdiction of a court in criminal matters is measured by the law in effect at the time of the commencement of the criminal action, rather than the law in effect at the time of the commission of the offense charge. Unsay pasabot ani? Nga when you file a case, ang prevailing nga balaod nga mo apply ana should be the law nga effective at the time nga pag-file nimo sa criminal action. Okay? Dili ang law nga effective at the time of the commission of the offense charge. Okay? For example, karon last year, there has been an amendment to the rules of court, particularly in civil procedure. Okay? Pananglitan ang cause of action ni occur in, let's say, 2018. Ang effective atong 2018 is ang rules of procedure in 2018. But the case was filed only in 2021, wherein the rules was already amended. Unsa may imong i-apply nga rules ana when you institute your case in court? Should it be the rules effective at the time of the commission of the offense, or at the time commission of the offense in 2018, or at the time of the filing of your complaint in 2021?
Time of filing.
Filing the complaint, attorney.
Yes.
2020.
Okay. Time of filing. You have to remember that. Na the rule that should apply when you institute a case should be the law that is effective at the time of the commission of the criminal action, rather than the law in effect at the time of the commission of the offense charged. Okay? Okay, I also want you to remember the principle of adherence of jurisdiction or continuing jurisdiction. In the past niya, nigawas ni kanang ipa-define sa bar examiner kung unsay pasabot sa principle of adherence of jurisdiction or continuing jurisdiction. When we talk about this principle is only referred to as a continuing in view of the general principle that once a court has acquired jurisdiction, that jurisdiction continues until the court has done all that it can do in the exercise of the jurisdiction. Okay? So kung ang RTC, by virtue of the allegations of the complaint, has already acquired jurisdiction over the offense of frustrated homicide, but the evidence offered during the trial shows that the commission of the offense was actually that of less serious physical injuries, as I've mentioned earlier, which is actually cognizable by the MPC. And if it is initially filed, the RTC here does not lose its jurisdiction over the offense charged and may impose the proper penalty for the offense proved by virtue of the principle of adherence of jurisdiction or continuing jurisdiction. Okay? So once the court acquires jurisdiction, it may not be ousted from the case by any subsequent events, such as a new legislation placing such proceedings under the jurisdiction of another tribunal. The only recognized exception to this rule arises when there's an express provision in the statute or when the statute is clearly intended to apply to actions pending before its enactment. Okay, so that's jurisdiction over the subject matter. This is the first one. Let's now go to jurisdiction over the person of the accused. Unsa man ning jurisdiction over the person of the accused? This only refers to the authority of the court, not over the subject matter of the criminal litigation, but over the person charged. Okay, over the person charged. Jurisprudence would teach us that jurisdiction over the person of the accused is acquired upon his arrest or apprehension, either it be with or without a warrant, or by his voluntary appearance or submission to the jurisdiction of the court. Okay, timan lahi ang jurisdiction over the person of the accused, kay ang jurisdiction over the person of the accused refers to the person charged as opposed to the jurisdiction over the subject matter, because ang jurisdiction of the subject matter refers man to the subject matter of the criminal litigation. Okay, now how does a jurisdiction over the person of the accused acquired, or how do we acquire the jurisdiction over the person of the accused? In criminal proceedings, okay, it is not sufficient for the court to acquire jurisdiction over the subject matter. Remember that. It also needs to acquire jurisdiction over the person of the accused. As what we have mentioned earlier, nga ang jurisdiction or ang jurisdiction over the subject matter is conferred by law. Now, ang jurisdiction on the person of the accused is conferred or acquired upon his arrest or apprehension, whether with or without a warrant, or his voluntary appearance or submission to the jurisdiction of the court. Once nadakpan na si akusado, ang person over his, or ang jurisdiction over his person is already acquired by the court. It could be nga wala siya nadakpan, but ning voluntarily appear siya or ning submit siya sa jurisdiction sa court, kana pod considered na ang iyahang person to have, or the court is already considered to have jurisdiction over his person. Okay? Now, kanusa man ka makaingon nga ang voluntary submission can actually give rise to the acquisition of jurisdiction of the court over the person of the accused. As a rule, the one who seeks an affirmative relief is deemed to have submitted to the jurisdiction of the court. And so may pasabot, ana, when you file pleadings seeking for affirmative relief, it already constitutes voluntary appearance, and the consequent jurisdiction of one's person to the jurisdiction of the court. Okay? So kung mo-file kag mga several motions before the RTC and you actually seek the dismissal of the criminal case, you are deemed to be voluntarily submitting yourself to the jurisdiction of the court. Okay? File ka diha sa mga motion for resetting or whatever motion that you may actually file seeking for, perhaps you will file a motion to dismiss or motion to quash, you're already voluntarily submitting to the jurisdiction of the court. Okay? The voluntary submission of the accused to the jurisdiction of the court is accomplished either by his pleading to the merits, such as filing of a motion to quash, or other pleadings requiring the exercise of court's jurisdiction. appearing, pwede pod nang mo appear siya for arraignment or mo enter siya during the trial. That's considered voluntary appearance, okay? And remember that because of that voluntary submission, di ba, nakuha na sa court ang jurisdiction over his person. So, unsa may consequence ana kung subsequently di siya mo appear during the trial or kung subsequently mo escape siya from the custody of the law? Will the court lose its jurisdiction over his person? Huh?
No, attorney.
No, okay?
attorney.
If he subsequently fails to appear during the trial or perhaps escapes from the custody of the law, ang jurisdiction over his person is not lost, okay? Because, as we've said earlier, once jurisdiction is acquired, or the jurisdiction once acquired is not lost but continues until the case is terminated. Okay? So, bisan pag mo iskapo na siya, bisan pag magtago-tago na siya or di na siya mo appear during trial, ang jurisdiction over his person will not be terminated or it will not be lost. What happens is that the trial will proceed and then judgment will be rendered. Either it could be in his favor or it could be unfavorable against him. Okay? You have to remember also that not all acts seeking affirmative relief would constitute a voluntary appearance or submission to the jurisdiction of the court. Okay? Kung muhimo ra kag special appearance sa court to question its jurisdiction over the person of the accused, it will not be considered a voluntary appearance. Okay? Likewise, there can be no submission to the jurisdiction of the court when the accused files a motion to quash the warrant of arrest because it is the very legality of the court process forcing the submission of the person to the accused. Okay? So that is, if that is the very issue of the motion to quash the information or the warrant of arrest because of the jurisdiction, because of questioning the jurisdiction, there can be no voluntary appearance or voluntary submission in this case, even if you file a pleading or a motion to that effect. Okay? Now, pwede ba nga na ay injunction in criminal prosecution, or can an injunction be issued to restrain criminal prosecution? By the way, unsa man din ang injunction? You know what is an injunction? What an injunction is all about? When we talk about an injunction, this is actually an order, guys, granted by the court. It could either be at any stage of an action or proceeding prior to the judgment or final order, requiring a party or a court, agency, or a person to refrain from a particular act or acts. Meaning, imong pahunungon or imong i-prohibit or imong i-restrain ang particular person from proceeding with a criminal prosecution. Is it allowed? As a general rule, it is an established judicial policy that injunction cannot be used to thwart criminal prosecution because investigating criminal acts and prosecuting their perpetrators have always been in the interest of the public. Okay? But there are exceptions. There are exceptions, however, to this general rule. Okay? Unsa man kahani nga mga exceptions. Una, when the injunction is necessary to afford adequate protection to the constitutional rights of the accused. When it is necessary for the orderly administration of justice or to avoid oppression or multiplicity of actions. Third, when there is prejudicial question, which is sub judice. Okay? When the acts, kani nga mga concepts, we will discuss this thoroughly later in our subsequent discussions. When the acts of the officer are without or in excess of authority, when the prosecution is under an invalid law, ordinance, or regulation, when double jeopardy is clearly apparent, or when the court has new jurisdiction over the offense, or where it is a case of persecution rather than prosecution, or where the charges are manifestly false and motivated by the lust or vengeance, and when there is clearly no prima facie case against the accused and a motion to quash on that ground has been denied. Okay. Lately, the bar examiners no longer ask questions which actually would actually ask you to enumerate, no? Wala na kayo ni, but for purposes of having a working knowledge on this one, remember nga sa general rule, dili ka pwedeng mo file injunction ha to restrain a criminal prosecution. Okay? Nga naman, because ang giapas aning criminal prosecution is to protect the public from criminal acts. Okay? If you allow injunction, whether it be preliminary or final injunction, to actually overtake your criminal prosecution, ang imuhang ends of justice or imong purpose for which criminal procedure is actually existing, mawa na, ma-defeated na. Okay? Kaya nga na to, because ang policy of the state or of criminal prosecution is intended to protect the public from criminal acts. So as a general rule, injunction to restrain criminal prosecution is not allowed. It cannot be used to thwart criminal prosecutions, except as otherwise enumerated in the subsequent paragraph. Aning a slide. Okay? So that's jurisdiction over the person of the accused. Let's now have jurisdiction over the territory. Or simply put, this is where the venue of criminal cases is. Okay? So unsa may aha man nimo i-file kay bawo na ka na it's in the either in the RTC or in the MTC. Okay? Kay bawo na ka because ningon ang balaod, jurisdiction is conferred by law. You already know that when the imposable penalty of the crime does not exceed 6 years, you know that it should be with the MTC. Okay? But the question now is, which MTC? Asa dapit ng MTC? Daghan man kayog MTC. Okay? A very important principle in relation to jurisdiction over the territory is that in criminal cases, timan yun ni guys, in criminal cases, venue is jurisdictional. Okay, jurisdictional. And a court is bereft of jurisdiction to try an offense committed outside of its limited territory. Okay? Thus, the court in very clear terms explains that the place where the crime was committed determines not only the venue of the action, but is an essential element of jurisdiction. Okay, it is a fundamental rule that for jurisdiction to be acquired by courts in criminal cases, the offense should have been committed or any of its essential ingredients should have taken place within the territorial jurisdiction of the court. Okay, so territorial jurisdiction in criminal cases is the territory where the court has jurisdiction to take cognizance or to try the offense allegedly committed therein by the accused. Thus, it cannot take jurisdiction over the person charged with an offense allegedly committed outside of that limited territory. So, example, kani ka no? Si Pablito, iyang let's say gikulata si Chande dito sa Lapu-Lapu. Okay? Example, Gikulata ni Pablito si Chande dito sa Lapu-Lapu. Pablito lives in Naga. Okay? Pablito lives in Naga. Chande is living in Cebu City. Question: which court should take cognizance or which court has jurisdiction over the case of, let's say, serious physical injuries? Or let's say less serious physical injuries. Kabauta nga MTC, less serious physical injuries. But asa man nga MTC, the crime was committed in Lapu-Lapu. The accused, Pablito, is living in Naga. The victim or the private complainant is living in Cebu City. By virtue of this element, kaning requisite to valid jurisdiction, asa man nato i-file ang kaso for less serious physical injuries? Which venue?
Lapu-Lapu, attorney.
Yes, that's correct. Okay? Ano to? Territorial jurisdiction in criminal cases is the territory where the court has jurisdiction to take cognizance or try the offense.
Lapu-Lapu, attorney.
It should be in Lapu-Lapu. O saan to pag-determine mo, the offense should have been committed. It should be the place where the offense should have been committed, or any one of its essential ingredients should have taken place within the territorial jurisdiction of the court. For example, kani, gikidnap ni Pablito si Chande gikan sa Lapu-Lapu. Niagi siya sa Mandawi. Sakay silag auto, agi siyag Mandawi, agi siyag Cebu City, agi siyag Talisay, Mingla, ngadtos Naga. Ditos Naga niya gidas Chande. Okay? So, unsa may kidnapping is the imposable penalty is above 6 years. So kabauta nga RTC. Pero asa man nga RTC, i-file kaha ang kidnapping against Chande.
Naga, attorney.
RTC of
Sa
Lapu-Lapu.
Mandawi.
Naga, attorney.
Lapu-Lapu and Naga, attorney. RTC Lapu-Lapu and RTC
Naga and context sabihin Lapu-Lapu, attorney.
Point A to point B, attorney.
From Lapu-Lapu to Naga.
Anywhere.
Yeah. Mandawi, Cebu City, Talisay, Minglanilla, Naga.
Yes. So, bisag asa nga iyang nagian, okay? From Lapu-Lapu to Mandawi to Cebu City to Talisay to Mingla to Naga, okay? Because this is actually a transitory crime. So kung asa siya naagi, it could actually have jurisdiction over the territory. But of course, they pwede nimong simultaneous i-file. Usara. So kung asa primerong na-file, kato siya ang dunay jurisdiction over the case. Okay? So that's basically the concept of venue. Okay? For a complaint or information to be sufficient, the same must enable the court, through the allegations therein, to determine that the offense was committed or any of its essential ingredients occurred at some place within the jurisdiction of the court. Hence, the rule places the venue of criminal cases either in the court of the municipality or territory where the offense was committed or where any of its essential ingredients actually occurred. So later sa ato ang study aning criminal procedure, I will ask you to prepare a complaint. Okay? In the preparation of complaint, kailangan makita nato dito ang mga elemento niya nga gi-require para makita nato ang allegations in the complaint, if we can identify kung unsa ang jurisdiction over the subject matter, kung unsa ang jurisdiction over the territory. Okay? So, now on to the different jurisdiction or criminal jurisdiction of trial courts. Okay? Do not tayo nagkalain-lain ng mga trial courts. We have the criminal jurisdiction of the municipal trial court. kanang trial court in a municipality, kanang municipal circuit trial court. When you talk about municipal circuit trial court, kana ganing trial court in a municipality nga gi-join like that of Liloan and Compostela. Circuit trial court man na siya, municipal circuit trial court kay duha ka municipality ang gida niya. Okay, muna gitawag og municipal circuit trial court. Now we also have metropolitan trial court. Kung kana siya nga trial court is for a particular metropolitan. Okay? We also have the criminal jurisdiction, but basically pareha na sila ha, ng MTC, MCTC o Metropolitan Trial Court. We also have the criminal jurisdiction of the regional trial court and of course the criminal jurisdiction of the Sandiganbayan. Okay? Now, unsa man ang mga cases that actually fall within the jurisdiction of the municipal trial court or of the MCTC or of the Metropolitan Trial Court. Okay? According to BP bilang 129, except in cases falling within the exclusive original jurisdiction of the RTC and of the Sandiganbayan, the municipal trial court shall exercise the following criminal jurisdiction. Una ana, exclusive original jurisdiction over all violations of city or municipal ordinances committed within their respective territorial jurisdiction. Okay? Mga violations sa mga ordinances, it should be within the jurisdiction of the MTC. Also, it has exclusive original jurisdiction over all offenses punishable with imprisonment not exceeding 6 years. Morning yung natong conferred by law. Jurisdiction over the subject matter is conferred by law. The law that actually confers jurisdiction over a particular crime is BP bilang 129. BP bilang 129 says that the MTC has exclusive original jurisdiction over all offenses punishable with imprisonment not exceeding 6 years, irrespective of the amount of fine. Bisag pila pa na ang fine, okay? And regardless of the other imposable or accessory penalties, including the civil liability arising from such offenses, irrespective of kind, nature, and amount, okay? Note here that the jurisdiction of the MTC is qualified by the phrase except in cases falling within the exclusive jurisdiction of the RTC and Sandiganbayan. Okay? This only means that ang MTC does not at all times have jurisdiction over the offenses punishable with imprisonment not exceeding 6 years. Okay? This can happen if ang jurisdiction is vested by law either in the RTC or Sandiganbayan. Because as I've mentioned before, na ay mga crimes nga bisan pa man og wala ning lapas og 6 years, ang iyang jurisdiction kay naas RTC or it could be with the Sandiganbayan. Okay? Example, ana kato akong giingon ganiha nga crime of libel. Diba? Crime sa libel. Ang crime sa libel is actually committed by means of writing or similar means, and it is punishable by prison correctional in its maximum or in its minimum and medium period, or a fine ranging from 200 to 6,000 pesos or both. Kaning prison correctional basically does not exceed 6 years. Pero under the revised penal code, ningon siya dito nga ang criminal action as well as its civil action for damages shall be filed with the regional trial court and not in the MTC. Okay? Mo nang gi-qualify sa kaning introduction, except in cases falling within the exclusive and original jurisdiction of the RTC and of the Sandiganbayan, the MTC shall exercise the following criminal jurisdiction. So kung ang balaod mismo niingon nga bisan pag dili siya Bisan pa og ang penalty imposable does not exceed 6 years, if the law says that it should be punished or it should be triable, or the court that has jurisdiction should be with the RTC, what tayo mahimo because it is what the law says. Okay, these are just some of the examples wherein even if it does not exceed 6 years, ang naay jurisdiction will be the RTC. Okay, another is exclusive original jurisdiction over offenses involving damage to property through criminal negligence. Okay, kana bitong reckless imprudence resulting in malicious mischief. Kana damage to property through criminal negligence. These are triable, or the court that has jurisdiction over these cases will be the MTC. Okay. Another one is kanang violations of BP 22. Bisag unsa pa nakadako ang balor sa cheque, bisan pag maabot nag 10 million, 11 million, 15 million. Okay? If that is a violation of BP 22 or bouncing checks law, the court that has jurisdiction over that particular case will be the MTC. Okay? The Municipal Trial Court. Also, summary procedure in certain cases, ato na tan-awon unsa nang mga summary procedure, and special jurisdiction to decide on applications for bail in criminal cases in the absence of all RTC judges in a province or city. There can be an instance wherein tanang mga RTC judges sa province or city nag-conference, and then there is a pending application for bail na very urgent, and there's no one to act upon it. The MTC in this case can have special jurisdiction to decide on applications for bail, okay, in the absence of all, tanawa ha, of all the RTC judges, okay, in a province or a city. Another is summary procedure in criminal cases. Unsa may mga summary procedures over which the MTC has jurisdiction. Okay, in metropolitan trial courts, in municipal trial courts in cities, and municipal trial courts and municipal circuit trial courts shall have jurisdiction over cases falling under summary procedure committed within their jurisdiction. The following are the subject of summary procedure. Una, violation of traffic laws, rules, and regulations. Okay? Kanang mga violations sa mga rules and regulations sa traffic, summary procedure na, and it falls within the jurisdiction of MTC. Violation of the rental law. Okay? It could be that you violate the rental law. You are the lessor. You violate the law on rents. So, violation of the same is cognizable with the MTC or by the MTC. Also, BP 22 cases, it is considered to be summary procedure in nature. So MTC, violation of municipal or city ordinances, and all other crimes or criminal cases where the penalty prescribed by law for the offense charge is imprisonment not exceeding 1 year. In the past, this is not exceeding 6 months. But by virtue of the amendment in Administrative Matter number 08-8-7-SC, gi-increase ang imprisonment to 1 year, okay? Not exceeding 1 year. Or a fine not exceeding 50,000 pesos. In the past, this is only 1,000, okay? To increase. Or both, irrespective of other imposable penalties, accessory or otherwise, or of civil liability arising therefrom. And offenses involving damage to property through criminal negligence, where the imposable fine does not exceed 150,000 pesos. Amended, said Nisia. Before, this is only, I think, if I remember it correct, 10,000 pesos. But by virtue of Administrative Matter number 08-8-7-SC, this has been increased to 150,000 pesos. Okay? Remember nga when you actually file a criminal case under summary procedure, this may be initiated by either a complaint or information. Okay? In Metro Manila and other chartered cities, the filing shall be by the information mag-wonder gid mo kabaw ko nag-wonder mo unsa ka ng information no unsa ka ng complaint no later on tagsa-tagsaon na nato ang rule sa how does the rule actually define information, how does it define complaint, what is the difference between the two concepts, okay? So ang kanang imong i-file under summary procedure, the complaint or information that you file under summary procedure shall be accompanied by the affidavits of the complainant and his witnesses in such number of copies as they're accused, plus 2 copies for the court's files, okay? This requirement has to be complied with within 5 days from the filing of the case. Otherwise, pwedeng ma-dismiss ang kaso, okay? Also, the affidavits required to be submitted shall state only facts of direct personal knowledge of the affiance. Di pwede chismis, okay? So, in the preparation of a complaint, di ka pwedeng marites. Kailangan, what you have to state there will be of your direct personal knowledge, okay? The affidavit shall also show the competence of the affiance. Okay, good afternoon once again to everyone and welcome to our class in criminal procedure. Last meeting, we discussed the different factors affecting the valid jurisdiction. We also discussed the concept of criminal procedure, as well as other matters relating to the basic principles of criminal procedure. Last meeting also, we started discussing the criminal jurisdiction of trial courts. Oh, my internet is unstable. I'll just turn off my camera. Okay. Again, last meeting, we discussed initially some of the cases that fall within the jurisdiction of different trial courts. We started with the criminal jurisdiction of the municipal trial court, the municipal circuit trial court, and the metropolitan trial court. And we stopped with the jurisdiction of the municipal trial court, MCTC, MTC, on the summary procedure in criminal cases. So just to recap, the metropolitan trial courts, the municipal trial courts in cities, the municipal trial courts, and the municipal circuit trial courts shall have jurisdiction over cases falling under summary procedure committed within their jurisdiction. This is according to the 1991 rule on summary procedure. Now, what are these cases that are subject to the summary procedure? Una diha, ang violation of traffic laws, rules, and regulations, the violation of the rental law, the BP bilang 22 cases or the bouncing checks, the Anti-Bouncing Check Act, the Philippines, that's BP bilang 22, the violations of municipal or city ordinances, all other criminal cases where the penalty prescribed by law for the offense charged is imprisonment not exceeding 1 year or a fine not exceeding 50,000 pesos or both, irrespective of their imposable penalties, accessory or otherwise, or of the civil liability arising therefrom. This has been amended by Administrative Matter 08-8-7 of the Supreme Court. And also offenses involving damage to property through criminal negligence, where the imposable fine does not exceed 150,000 pesos. Again, this has been amended by AM number 08-8-7 SC. Now, you might ask, unsa man di ay difference kung kani siya attorney falls within the summary procedure? Kung summary procedure manggod, you have to remember nga in summary procedure, this can either be initiated by a complaint or information. But remember that in Metro Manila and other chartered cities, the filing shall be by information, except when the offense is one which cannot be prosecuted de officio. Okay? So as a general rule, kung mo-file ka o case falling under summary procedure, it should either be by a complaint or information. As I've said, we will discuss the definition of complaint and information later on in our discussion. This falls within Rule 110. And gi-qualify nga if it falls in Metro Manila and other chartered cities, kung mo-file ka og case under summary procedure, it shall be by information. Except kuno kung ang offense is one which cannot be prosecuted de officio. Unsa nang offense which cannot be prosecuted de officio? Kanang offense nga dili pwedeng ma-initiate with another person. It can only be initiated by the private offended party, which you will later on learn in our discussion. Now, under the rules on summary procedure, the complaint or information shall be accompanied by the affidavits of the complainant and his witnesses in such number of copies as they are accused, plus 2 copies of the court's files. Okay? So when you file a complaint or information in court and the case falls within summary procedure, i-attach na nimo diha ang inyong judicial affidavits kung ikaw complainant and the judicial affidavits of your witnesses. Okay? This requirement has to be complied with within 5 days from the filing of the case. Otherwise, ma-dismiss na ang kaso. Okay? Also, under the rules on summary procedure, the affidavits required to be submitted shall state only facts of direct personal knowledge of the affiants. Dili pwede chismis, okay? Ang affiant di pwede marites. Kailangan ang iyang ibutang diha sa judicial affidavit has to be of his or her direct personal knowledge. Okay? Iyahag yung nahibawan. Dili kay iyarang nabati sa uban. The affidavit shall also show the competence of the affiants to testify to the matters stated therein. A violation of this requirement is a ground for disciplinary action against the party or counsel who submits the affidavit. And it is also a ground for the inadmissible affidavit or a portion of it to be expunged from the record. That's according to Section 20 of the Rules on Summary Procedure. Also note that should the court find no cause or ground to hold the accused for trial, it shall order the dismissal of the case. If tanawon ni judge nga kaning kasuha, there's no basis for it to hold the accused for trial, this should be dismissed, okay? And if there's ground to hold the accused for trial, the court shall set the case for arraignment and trial. Dili siya mo issue warrant of arrest, okay? Padadaan ra nagsubpina ang accused nga set na siya for arraignment and then later on trial, okay? Also under the rules on summary procedure, it states that if the accused is in custody of the crime charged, he shall be immediately arraigned. And if he enters a plea of guilty, he shall forthwith be sentenced, okay? Also note that under the summary procedure, para namoy idea, you can download a copy of the rules and summary procedure. But under the rules, before conducting the trial, the court shall call the parties to a preliminary conference during which the following may be done. So mura na siya pre-trial po. So preliminary conference. In the preliminary conference, before na mag-trial, hisgutan diha ang mga stipulation of facts. Okay? Pangutanaw ni judge, unsa may angkunon sa mga parties, unsay angkunon nimo complainant, unsay angkunon nimo accused. Buhan, inig-trial na, gamay na lang ang ilang lalisan. Okay? Mo na siya ang entering into a stipulation of facts. Also, the parties will consider the propriety of allowing, or the court will consider the propriety of allowing the accused to enter a plea of guilty to a lesser offense. Also in the pre-trial conference, pwede po mo plea bargain ang accused in that case in the summary procedure. But of course, this will be upon the consideration and discretion of the court. Also, i-take up with diha ang other matters to clarify the issues and to ensure a speedy disposition of the case. Kay ang purpose aning summary procedure nga mapaspas ang pag-dispose sa kaso. That's why it's very fast, very efficient. You are required to submit all your affidavits, all the affidavits of your witnesses, as opposed to an ordinary criminal case nga you are not required to submit a judicial affidavit when you present your witness. But in a summary procedure, it is mandatory that upon filing your complaint or information, all the affidavits of the complainant as well as the witnesses are already enclosed in the said complaint or information. Okay? Now also remember that during the trial, an actual direct examination of the witness is not required because the affidavits submitted by the parties will now constitute as their direct testimonies. Okay, di ba? Ingon ko earlier na upon filing of the complaint and information, all the affidavits, judicial affidavits of the witnesses and the complainant are already in the court. Okay, it's already enclosed in the complaint or in the information. So, inipresentara na sa trial during the direct examination, dili na kailangan conduct ang actual direct examination. What is to be done is ipa-identify ra ni counsel sa iyahang testigo, let's say the private complainant, he will only ask the private complainant to identify the judicial affidavit executed by the said complainant. So the counsel would now ask, do you remember having executed a judicial affidavit in relation to this case? So moingon na ron si private complainant, yes. And then the counsel would now ask, do you confirm and affirm all the allegations in this judicial affidavit? Moingon sa dayon si private complainant, yes. And then mo-manifest na dayon na ang counsel nga, Your Honor, the judicial affidavit of the witness in this case or of the private complainant in this case will be deemed as his or her direct testimony in this case. But just because wala na naiyahang usual nga direct testimony doesn't mean nga wala na cross-examination, redirect examination, or re-cross-examination, okay? After the identification of the judicial affidavit and the manifestation that the judicial affidavit of the witness or the complainant, as the case may be, will serve as his or her direct testimony, the opposing party would now have the opportunity to conduct cross-examination. Okay? So based atong judicial affidavit nga gipa-identify, si opposing party now, example, the accused now would now have the chance to cross-examine the witness or the private complainant as the case may be. So after sa cross-examination, conduct na po ng redirect examination and recross examination. Okay? And remember na kung ang affiant failed to testify on the said affidavit, ang iyahang affidavit shall not be considered as competent evidence for the party presenting the affidavit. Okay? Dili pwede nilang magamit nga ebidensya kung di na mo nga aron ni-identify ang affidavit ug aron ma-subject siya to cross-examination. Okay? However, si adverse party or si opposing party may utilize the same for any admissible purpose. Okay? And then also note that what's the beauty of the rule on summary procedure in criminal cases is that the court is mandated not to order the arrest of the accused. Okay? Dili jud siya mandated, di siya mandatory nga there be an arrest on the part of the accused. Except kung ang ground is for the failure of the accused to appear when required by the court. Okay? Kung during pre-trial, wala siya motunga, during the preliminary conference, during the presentation of evidence, wala siya nito nga, the court can now issue a warrant of arrest, okay? A warrant for his arrest. And if he is arrested, he may be released on bail or on recognizance by a responsible citizen acceptable to the court, okay? And then, remember na kung mahuman na ang trial, if the trial has already been conducted, the court shall, under the rules, promulgate the judgment not later than 30 days after the termination of the trial. So in ana kapaspas ang summary procedure as opposed to the usual or the ordinary criminal case lodged before the MTC, MCTC, or Metropolitan Trial Court. Okay, so just take note of the cases that fall within the jurisdiction of the MTC under summary or subject to summary procedure. All right. Now, what are the prohibited pleadings, motions, and petitions in summary procedure? Pwede ra ba tang maka-file bisag unsang motion diha in summary procedure? The answer is no, because the purpose of summary procedure is to actually fast track the disposition of the case. So that's why ang mga pleadings, motions, and petitions that are practically dilatory in nature are not allowed to be filed before the court, subject to the summary procedure. So unsa maning nga mga pleadings, motions, and petitions that are not allowed under the rules on summary procedure? Una, kaning motion to quash the complaint or information, or motion to dismiss the complaint, except if the ground is for lack of jurisdiction over the subject matter or failure to comply with the barangay conciliation proceedings. Second, motion for bill of particulars. Kanang motion for bill of particulars is like a motion clarifying ba ang allegations sa complaint libog. So gusto ka ipaklaro nimo unsa man gyud ang imong gipangayo aning imong kaso. Kanang BP bilang 22 or naningil ba ka sa imong utang nako. So basically vague ang complaint or information, so the party or the accused can file for, or the party would now file for a motion for bill of particulars. Under the rule on summary procedure, a motion for bill of particulars is not allowed. Okay? The motion for new trial or for reconsideration of judgment or reopening of a trial, also not allowed under the rule on summary procedure. Also, petition for relief from judgment. Angay rin siya sa mga ordinary cases. Okay? Motion for extension of time to file pleadings, affidavits, or any other paper. Naturally, di siya allow because the objective of the rule on summary procedure is for the speedy disposition of case. And if you allow this, it will only delay the procedure or the process. Memoranda, petition for certiorari, mandamus, prohibition against any interlocutory order issued by the court, motion to declare the defendant in default, dilatory motions for postponements, reply, third-party complaints, and interventions. So basically, these are just some of these are the prohibited pleadings, motions, and petitions in summary procedure. You cannot file these motions, pleadings, and petitions before the MTC subject to the summary procedure. So take note of that. Now we go to the criminal jurisdiction of the regional trial court. Magmanata sa municipal trial court, we now proceed with the RTC, okay, the regional trial court. The regional trial court shall exercise the following jurisdiction. This is under BP 129 as amended by RA 77691. The regional trial court, ladies and gentlemen, shall have exclusive original jurisdiction in all criminal cases. Ako lang yun ning klaruhon sa inyo ha na this is criminal procedure. So we focus on the jurisdiction in criminal cases or criminal actions, okay? That's why, as you can see, puro ni criminal cases ang naadri sa atong discussion. You will also have a similar discussion on civil procedure. So maghisgot sad mo diha sa civil procedure og mga cases that fall within the jurisdiction of different trial courts. But for purposes of this subject, we focus on criminal cases, okay? So the RTC shall exercise exclusive original jurisdiction in all criminal cases not within the exclusive jurisdiction of any court, tribunal, or body, except those now falling under the exclusive and concurrent jurisdiction of the Sandiganbayan, which shall be exclusively taken cognizance of by the latter. And then, original jurisdiction in the issuance of the writs of certiorari, prohibition, mandamus, quo warranto, habeas corpus, and injunction enforceable in any part of their respective regions. Tanawa niya, kaning mga writs on certiorari, prohibition, mandamus, quo warranto, kaning certiorari is you are actually saying that a court, a tribunal, or an office has actually exercised a grave abuse of discretion amounting to lack or excess of jurisdiction. So basically, that's the essence of certiorari. Prohibition, you want to prohibit something from happening. Mandamus is if you want to compel someone to do something. Quo warranto, in relation to election cases. Habeas corpus, if you want to have someone be brought before the court. Habeas corpus is from the word abyar. Abyar is to bring, corpus is body. So to bring the body of the person in court. And then injunction, that is also, we also discussed that in the past. Ang kaning mga writs, if this is issued by the RTC, ang iyang enforceability, tanawa ha, is only in the respective region, okay? So these writs may in certain cases be availed of in criminal cases. For purposes of having working knowledge on this one, you can actually check on your rules, no? Naapod ni diha ang definitions of certiorari, prohibition, mandamus, quo warranto, habeas corpus, and injunction. But I just want you to note that the enforceability of these writs, if this be issued by the RTC, is within the region, okay? Within the region. So example, it's issued in Region 7, that's the 7th Judicial Region of Cebu City. So the enforceability of the same is within the jurisdiction of the 7th Judicial Region. So within the Region 7, ang iyang enforceability. Okay? So basta RTC. You will also learn later on that if it's issued by the Supreme Court, the enforceability is within the entire country. Another case that fall within the jurisdiction or that falls within the jurisdiction of the RTC is the appellate jurisdiction over all cases decided by the MTC within its territorial jurisdiction. So, kung if, example, napildi ang accused in the MTC over a BP22 case, ang iyang resort now would be to appeal before the RTC. So the RTC has appellate jurisdiction over cases decided by the MTC within its territorial jurisdiction. Also, the RTC has special jurisdiction of certain branches to handle exclusively criminal cases as may be determined by the Supreme Court. Jurisdiction over criminal cases under specific laws such as jurisdiction over criminal and civil aspects of written defamation, kanang libel, katotong gisgutan before. Jurisdiction of designated special courts over cases in violation of Comprehensive Drugs Act of 2002. Jurisdiction of designated RTC branches for violations of intellectual property rights. The jurisdiction to try all cases on money laundering. However, those committed by public officers and private persons who are in conspiracy with such public officers shall be under the jurisdiction of the Sandiganbayan, which you will see later on, okay? So basically, these are the cases that fall within the jurisdiction of the RTC. Timan ilang ni kaning mga cases that do not fall within any other tribunal. And remember, also, the imposable penalty exceeds 6 years. Original jurisdiction over issuances of writs of certiorari, prohibition, mandamus, co-warranto, habeas corpus, and injunction, and then these cases, appellate jurisdiction sa MTC, and then criminal cases under specific laws. Okay, remember that. Now on to the criminal jurisdiction of the Sandiganbayan. Remember that the jurisdiction of the Sandiganbayan, ladies and gentlemen, is set out by Presidential Decree 1606 as amended, and not by RA 3019 or the Anti-Graft and Corrupt Practices Act. So, unsa may mga cases that fall within the original jurisdiction of the Sandiganbayan. So, these are the cases. Una, violations of Republic Act number 3019 as amended, or otherwise known as the Anti-Graft and Corrupt Practices Act, particularly, and RA number 1379 and Chapter 2, Section 2, Title 7, Book 2 of the Revised Penal Code. Tanawa ang phrase, guys, nga, where one or more of the accused are officials occupying the following positions in the government. Excuse me. So whether one or more of the accused, meaning kung duha or tulo sila, ang importante raani nga usa nila official occupying positions in the government nga atong i-enumerate ron tagsa-tagsa. And napagi-laing qualification, bisan pag ang capacity is permanent, acting, or interim capacity at the time of the commission of the offense. Okay? Just note of that, where one or more of the accused are officials occupying the following positions in the government, whether in a permanent, acting, or interim capacity at the time of the commission of the offense. Kinsa man ni nga mga officials? We'll see. Kaning officials of the executive branch occupying the positions of regional director and higher, otherwise classified as salary grade 27 and higher of the compensation and position classification of 1989, specifically including kanisila provincial governors. If you remember, si Governor Gwen Garcia sa una had a case in Sandiganbayan, diba? But that was already dismissed. The vice governors, members of the Sangguniang Panlalawigan, provincial treasurers, assessors, engineers, and other provincial department heads. Basically, mga provincial officials ni sila ha, either of elective positions or appointive positions. City mayors, vice mayors, members of the Sangguniang Panlunsod, city treasurer, assessors, engineers, and other city department heads. They are under the jurisdiction, criminal jurisdiction of the Sandiganbayan. Okay? The officials of the diplomatic service occupying the position of consul and higher. Insa pa man, Philippine Army and Air Force colonels, naval captains, and all officers of higher rank, officers of the Philippine National Police while occupying the position of provincial director, and those holding the rank of senior superintendent or higher, city and provincial prosecutors and their assistants, and officials and prosecutors of the Office of the Ombudsman and special prosecutors, the presidents, the directors, and the trustees or managers of the government-owned or controlled corporations, state universities or educational institutions or foundations. Also, the members of Congress and officials thereof, classified as grade 27 and up under the Compensation and Position Classification Act of 1989. The members of the judiciary without prejudice to the provisions of the Constitution, because there are some members of the judiciary, especially members of the Supreme Court, mga judges that are or that fall within the jurisdiction of the Supreme Court mismo. Sila ang naay jurisdiction. Chairmen and members of the constitutional commissions without prejudice, of course, to the provisions of the Constitution, and all other national and local officials classified as grade 27 and higher under the Compensation and Position Classification Act of 1989. Now, in cases where none of the accused are occupying positions corresponding to salary grade 27 or higher as prescribed in the law or military and PNP officers mentioned above, exclusive original jurisdiction thereof shall be vested in the proper regional trial court, metropolitan trial court, municipal trial court, MCTC, as the case may be, pursuant to the respective jurisdictions as provided in BP 129. Unsa may pasabot ani? Example ko na. A police officer charged with bribery. Example lang ni. And let's say and let's say bribery is penalized with less than 6 years. I think less than 6 years raw ng bribery. And this PNP officer has a salary grade of 24. Okay? So example, example. Si Raymond. Okay? Example, si Raymond Cabal. A police officer with a salary grade of 24, charged with bribery. The imposable penalty under the law for the crime of bribery is an imprisonment of 2 years, 4 months, and 1 day up to 6 years. So that's below 6 years, diba? So karon, ang question, where do we file the criminal case against police officer Cabal in case we decide to file a case against him? Kinsa may na ay jurisdiction? A. Sandiganbayan, B. MTC, C. RTC, D. None of the above.
Legal.
What's your
B,
answer?
attorney.
RTC, attorney.
B, attorney. MTC, attorney.
MTC, attorney. MTC.
MTC.
Yes, MTC, okay? Kay ngano to? Kung wala siya ato na enumerate, atong gihisgutan ganiha na ang iyang position do not correspond to a salary grade of 27 or higher, ang naay jurisdiction nila shall be the proper RTC or MTC as the case may be. So in that case, kung saan man nimo pag-determine kung RTC siya or MTC, kay bao naman ka nga dili siya Sandiganbayan kay iyang salary grade is only 24. He is a police officer, salary grade 24. Ang iyang crime na commit bribery, ang penalty imposable under the law is below 6 years. So unsa man ang naay jurisdiction, it should be the unsa to inyong giingon?
MTC.
MTC, attorney.
Okay,
MTC
that's correct.
attorney.
MTC, all right? So mura na ang ato ang muna akong gipasabot, okay? Now the Sandiganbayan, however, shall exercise exclusive appellate jurisdiction over final judgment, resolutions, or orders of the RTC, whether in the exercise of their own original jurisdiction or of their appellate jurisdiction as herein provided. Okay? So kung mga gipang-apilar na sad nga kaso of a government official under RTC or MTC, ang naay appellate jurisdiction ana would be the Sandiganbayan and not the Court of Appeals. Okay? Also, the Sandiganbayan shall have exclusive original jurisdiction over petitions for the issuance of the writs of mandamus, prohibition, certiorari, habeas corpus, injunctions, and other ancillary writs and processes in aid of its appellate jurisdiction, and over petitions of similar nature, including mga warranto arising or that may arise in cases filed or which may be filed under EO numbers 1, 2, 14, and 14-A issued in 1986, provided that the jurisdiction over these petitions shall be exclusive or shall not be exclusive of the Supreme Court. Okay? Also, remember that the procedure prescribed in BP 129 or the Batas Pambansa bilang 129, kaning Batas Pambansa bilang 129 is the law that sets out the jurisdiction of the different trial courts. Ha? So i-check na ninyo. You can download the copies of or the copy of the same. The procedure prescribed in BP 129 as well as the implementing rules that the Supreme Court has promulgated and may herein promulgate relative to appeals, petitions for review to the Court of Appeals shall apply to appeals and petitions for review filed with the Sandiganbayan. Okay, shall also apply to Sandiganbayan. And in all cases elevated to the Sandiganbayan and from the Sandiganbayan to the Supreme Court, the office, di man iha, ang mahimong abogado ani sa state would be the office of the Ombudsman through its special prosecutor. Okay? The office of the Ombudsman through its special prosecutor shall represent the people of the Philippines in cases elevated to the Sandiganbayan and from the Sandiganbayan to the Supreme Court. Okay? In case private individuals are charged as co-principals, accomplices, or accessories with the public officers or employees, including those employed in government-owned and controlled corporations, they shall be tried jointly with the said public officers and employees in the proper courts, which shall exercise exclusive jurisdiction over them. Di ba pag-start na to kay naghisgutag one or more of them are public officers, nga na, if naa sila'y kauban nga akusado nga private individual, wala nagtrabaho sa gobyerno, ang ilahang kaso will not be separated, okay? If they are co-accused over the said case, they will be tried jointly, okay? Dungano na sila. And then, ang RA 7975 that confers jurisdiction over the Sandiganbayan, specified offenses. Nagklaro gyud dito, di ba? Nga where one or more of the principal accused or officials occupying the positions enumerated in the law. Remember lang that there's a significant amendment introduced by RA 8249. And the said significant amendment was the removal of the word principal. Kaysa una manggod, ang naa dito is one or more of the accused is the principal. So basically, ang naa na lang karon habilin is where one or more of the accused, okay? Mao ang nahabilin. So as the law is now written, an official no longer has to be a principal accused. Okay? Pwede siya nga accomplice or accessory. I'm sure you know or you will know later on in your criminal law the distinction between a principal, an accomplice, an accessory. I don't know kung naabot na mo diha, but maabot ra mo diha kung wala pa mo naabot in your criminal law. So karon under the law, dili na necessary nga ang usa sa mga accused kay principal accused. Okay? It is enough nga bisan pag-accomplice ra siya or accessory, they can be tried in the Sandiganbayan. Okay? Also, not all of the accused need to be those officials mentioned in the said law. It is sufficient that at least one of them be an official occupying any of the positions enumerated. Now you may ask, should one or more of the officials charged have a salary grade of 27 or higher for the Sandiganbayan to have jurisdiction over the case? Kinahanglan ba, attorney, nga ang usa nila or sobra pa sa usa nila ang macharjan kay naagyoy salary grade or nga macharjan ang naagyoy salary grade 27 in order for the Sandiganbayan to have jurisdiction over the case? According to our idol Riano, yun siya, na it is believed that the query be answered in the negative. Kaya nga naman daw, because the law mentions salary grade 27 only in relation to kani ay ng mga officials, kaning officials of the executive branch occupying the position of regional director and higher, members of Congress and other officials, and other national and local officials. These officials are those who are not enumerated in letters A to G of Section 4A1, katong atong gihisgutan earlier, okay? So, remember that the salary grade of 27 has no reference, for example, to provincial governors, vice governors, mga members of the Sangguniang Panlalawigan, diba? And other officials enumerated from A to G, katong atong gihisgutan earlier. So those enumerated are subject to the jurisdiction of the Sandiganbayan, regardless of their salary grades. So, tanawan eh. So kani sila regardless of their salary grades, because they are specifically enumerated in A, B, C, D to G, fall within the jurisdiction of the Sandiganbayan, even if they do not earn the salary grade of 27. Okay. In the case of Inding versus Sandiganbayan, the Supreme Court clarified that clearly, therefore, Congress intended these officials, regardless of their salary grades, to be specifically included within the Sandiganbayan's original jurisdiction. For had it been otherwise, then there would be no need for such enumeration. Okay, ngayon na Supreme Court. Also, this conclusion is further bolstered by the fact that some of the officials enumerated in A to G are not classified as salary grade 27 or higher under the position titles and salary grades of the Department of Budget and Management. So balik ko na to. Kani sila, these officials, provincial governors, city mayors, and Philippine Army, kaning PNP nga nag-occupy o provincial director ng mga positions, mga city and provincial prosecutors, presidents and directors of GOCCs and state universities or educational institutions, they fall within the jurisdiction, criminal jurisdiction of the Sandiganbayan, regardless of their salary grade. Okay? But kanina sila, are to be considered based on their salary grade. Kay giklaro man. Okay? But according to the Supreme Court, regardless of pilay sweldo aning mga tauhan ng A to G, they fall within the criminal jurisdiction of the Sandiganbayan. Okay? I want you to read the case of Inding versus Sandiganbayan for you to have a better understanding of this case. Okay? Okay, good afternoon. Once again, I'll try to turn on my camera. Okay. Okay, good afternoon. Once again, we will now start with the discussion on Rule 110, the prosecution of offenses. We will start off with Section 1 of Rule 110. Section 1 of Rule 110 provides that criminal action shall be instituted as follows. For offenses where a preliminary investigation is required pursuant to Section 1 of Rule 112, this should be done by filing the complaint with the proper officer for the purpose of conducting the requisite preliminary investigation. We've discussed this as our initial overview of the subject criminal procedure, di ba? Na kung kailangan ang preliminary investigation, you need to file a complaint with the proper officer, that is the prosecutor, with the prosecutor's office in order to conduct the requisite preliminary investigation. The second paragraph provides that for all other offenses, this is done by filing the complaint or information directly with the municipal trial courts and municipal circuit trial courts, or the complaint with the office of the prosecutor. Remember, in Manila and other chartered cities, the complaint shall be filed with the office of the prosecutor unless otherwise provided in their charters. O niya, hinumdumin ninyo ni ay kani na the institution of the criminal action shall interrupt the running of the period of prescription of the offense charged unless otherwise provided in special laws. Okay? Kani nga section basically applies to the commencement of criminal actions in RTC and other inferior courts. Okay? But ang procedures sa other inferior courts would be governed by Rule 123, which we shall discuss later on as we progress in our discussion. Okay? So, kani siya nga section on the institution of criminal actions for offenses falling under the jurisdiction of the RTC and MPTs or METCs or MCTCs specifically refers to the offenses not subject to the rule on summary procedure, okay? Thereby signifying that this section does not apply to offenses which are subject to summary procedure. Nga naman, lain ang mo govern ana nga rule when it comes to summary procedure, okay? For criminal actions for violation of municipal or city ordinances being subject to the summary procedure, if you remember, we enumerated the cases which are actually governed by the rule on summary procedure, if you can remember, one of which ay katong mga violations of municipal and city ordinances, diba? If the case is that of a violation of a municipal or city ordinances, niya governed man na siya by the summary procedure, ang period of prescription na niya is governed by Act number 3326, okay? 3326, which provides that such violations prescribe after 2 months and which period is interrupted by the institution of the judicial proceedings against the offender. Why am I talking about this? Because if you notice in Rule 110, the last paragraph says that the institution of the criminal action shall interrupt the running of the period of prescription of the offense charge unless otherwise provided in the special laws, okay? Unless otherwise provided in the special laws. So, let's just try to see kung unsa ang gi-provide under Act 3326. Unsa man di ay naa diha sa Act 3326. Ang Act 3326 is an act that establishes the periods of prescription for violations penalized by special acts and municipal ordinances and to provide when prescription shall begin to run. Unsa may naa diri, violations of special acts, etc., mao ni 1 year for offenses punished by a fine of imprisonment of not more than 1 month, 4 years kung imprisonment less than 2 years, more than 1 month but not less than 2 years, 8 years if it does not exceed 6 years, and then 12 years, so and so. But here, I want you to take note, ngayon dire, violations penalized by municipal ordinances shall prescribe after 2 months. Okay, 2 months. And then further in section 2, niingon siya, prescription shall begin to run from the day of the commission of the violation of the offense or violation of the law, and if the same be not known at the time from the discovery thereof and the institution of the judicial proceedings for its investigation and punishment. Now, the prescription shall be interrupted when proceedings are instituted against the guilty party and shall begin to run again if the proceedings are dismissed for reasons not constituting jeopardy. And then for purposes of this act, special act shall be acts defining and penalizing violations of the law not included in the penal code. So basically, you can presume that these refers to mga special penal laws. But I want you to remember, or before that, akong tagaan mo example kung unsaon pag-apply ng prescription ha. If example lang, kung ning violate og ordinansa si, let's say, sa classmate, si Pablito, okay? Ordinance on, let's say, bawal maglabay og basura sa daplin sa dan, which is a place nga dili allocated sa paglabay og basura, okay? The violation of the said ordinance was committed, let's say, May 11, 2022. Okay, May 11, 2022. Ang complaint na file with the Provincial Prosecutor's Office pag May 30, 2022. Complaint ha, complaint. And then the information was later filed in court on October 2, 2022. Can you move for the quashal of the said information on the ground that the offense had already prescribed? Pablito? Nakakuha mo sa problem? Or can you still hear me? Okay. Sinawa na ko. Balik ha. We are talking about the prescription of violations of ordinances, di ba? Kaning mga violations penalized by ordinances, municipal ordinances, niingunta under Act 3326 na it shall prescribe after 2 months. After 2 months, di ba? Now, in my example earlier, ko si Pablito violated a municipal ordinance on the prohibition to throw garbages in a non-designated area in their city, let's say Sanaga. Okay, Sanaga. The violation of the ordinance was committed on May 11, 2022. Are you following? Okay. And then the complaint was filed with the city prosecutor of Naga on May 30, 2022. Ang complaint ha, complaint. However, the information was filed in court only in October 2, 2002. Okay? If you've read in advance, you would know that an information is the accusation in writing. This time, this is subscribed by the prosecutor, di ba? Kaya ang complaint is a sworn statement man. Subscribed by either the offended party or any peace officer, public officer charged with the enforcement of the law violated. Now, the question is, can Pablito file for a motion to quash the information filed against him on the ground that the offense had already prescribed, since the information was filed only in October and it already lapsed the 2-month period provided for in Act 3326?
I believe so. Yes, attorney. He can quash it.
attorney.
Yes, attorney.
Yes, ha. The motion to quash would be proper on the part of Pablito because the offense in this case had already prescribed. Nga naman, because the information was already filed in court more than 2 months after the violation of the ordinance. The filing of the complaint to the provision of the city prosecutor did not actually interrupt the period in this case, unlike the rule on offenses diri aning atong section 1. Because if you can see, there is a section 1, the institution of criminal action shall interrupt the running of the prescriptive period of the offense charge unless otherwise provided in special laws. Ang pasabot ani during section 1 is that the mere filing of the complaint with the prosecutor's office already interrupts the running of the period of prescription. But it is different when it comes to Act 3326 because in Act 3326, if you remember, dire nga niyon dire nga the prescription shall be interrupted when proceedings are instituted against the guilty person and shall begin to run again if the proceedings are dismissed for reasons not constituting jeopardy. And this presupposes that there has to be already an information filed with the court. So you need to make a distinction, okay? So when it comes to summary procedure, such as this, no, kaning violation of ordinances, you need to remember nga ang reckoning point ana sa pag-interrupt sa running of the prescriptive period is the filing of the information and not the filing of the complaint. But later you will learn that giklaro pod sa Supreme Court na when it comes to special laws, special penal laws, the mere filing of the complaint already interrupts the running of the prescriptive period of an offense. But basin ma-confuse mo ba unsa din ang prescription of crime, attorney, or offenses? Wala mi idea ana. You will be discussing this thoroughly in your RPC or in your criminal law 1. This is part of your discussion, but as a background, ang mga crimes nga na-commit sa usa ka akusado or usa ka respondent, no, are not immediately penalized. Di na automatically nga, if you already commit a crime, you will be penalized automatically, because there are circumstances that would deter the offended party from filing criminal charges. There are times na ma-delay ang pag-file. There are times nga nagmuni-muni pa siya if mo-file ko or delay, and then there are times nga maka-decide na siya, and then later on ma-realize niya na it's already too late because it has already prescribed. Okay? Sometimes it may take years for the offenders or the perpetrators to pay for the crime they committed. However, the law prescribes a specific time within which an offender may be prosecuted for the crimes committed. Okay? Ang balaod, nag-ingon mismo nga, you only have this period within which to file your complaint or information. Okay? Pananglitan, nakakommit si X of murder. Ang murder has to be instituted, the crime of murder has to be instituted within a period of time. Okay? Nganong importante man to know the prescription period or the prescriptive period of a crime? Ngano importante, makuan ba di ay, mahimo ba di ay not guilty si person who committed it if nalapse na ang prescriptive period? It's very important to know, guys, the prescription of the crime, because kung ang offended party or ang proper authorities will not be able to file the case within the prescribed period, they will actually lose their right to prosecute the perpetrators. Okay? Dili na sila pwedeng mo file og case against the offenders or against the perpetrators if they already go beyond the prescriptive period. Under the revised penal code, particularly Article 90, the prescription of crime, ang mga crimes are actually classified into different categories o classify sa diha o pila ang number of years within which to institute the criminal action against the offenders or against the perpetrators. Kung ang crime is punishable by death, reclusion perpetua, reclusion temporal, kailangan mo file ka sa kaso within 20 years. Okay? Otherwise, after 20 years, mo prescribe na and you can no longer institute a criminal action against the offender or the perpetrator. Okay? Kung ang crime kay punishable by afflictive penalties, mo prescribe na siya in 15 years. Later on, you will also learn kung unsa ning mga crimes nga kaning pila man din ni kay years ang reclusion perpetua, pila man din ni kay years ang reclusion temporal, unsa man din ni nga mga crimes ang afflictive penalties, na unsa man din ni nga mga crimes ang correctional penalties. So you will have to commit to memory the classification of all these crimes para makabawsad mo kung kanus asad siya mo prescribe. So again, kung ang penalty imposed by law is death, reclusion perpetua, reclusion temporal, 20 years na siya. Kung afflictive penalties, 15 years na siya. Kung correctional penalty, mo prescribe na siya in 10 years. Okay? With the exception of those punishable by arresto mayor, which shall prescribe in 5 years. Unya, ang kaning crime sa libel and other similar offenses, mo prescribe na siya in 1 year. Okay? Ang oral defamation o slander by deed, mo prescribe na siya in 6 months. Okay? So, timanin na ninyo, kung naagani mo committer og libel against ninyo, timan kung kanus-ani na commit ang crime or kanus-ani mo na discover ang publication of the said libel, di ba? So it shall prescribe in 1 year. Kung oral defamation, kanus-aman siya ning storya nimo og mga bati in front of a lot of people, in front of a third person, kanus-amang ka gi slander by deed, so it shall prescribe in 6 months. Okay? For like offenses, 2 months ra na siya. Okay? Unya, Ang prescription, remember, ang prescription shall be interrupted when the proceedings are instituted against the guilty party and shall begin to run again if the proceedings are dismissed for reasons not constituting jeopardy. Now, in recent cases, ni-appear diri nga ang Supreme Court did not anymore adhere to the line told in the case of Saldivia, katong atong giingon diri ay katong atong giingon nga ang prescription of offenses or the interruption shall be based on the filing of the complaint when it comes to special laws or violation of special laws. Okay, in the case of Sanrio Company Limited versus Lim, this is actually a case involving a violation of the Intellectual Property Code. Special law. This is a special law, and when it is a special law, we mentioned earlier that the period of prescription should be governed by Act 3326. But according to the Supreme Court, dili na siya prevailing anymore, and the Supreme Court said that the filing of the complaint, the mere filing of the complaint for purposes of preliminary investigation interrupts the period of prescription of criminal responsibility. Okay. Thus, the prescriptive period for the prosecution of the alleged violation of the Intellectual Property Code was told by the petitioner's timely filing of the complaint affidavit before the assistant prosecutors or the assistant provincial prosecutor. Okay, so let's just make a distinction. When it comes to violations of special penal laws, violations of RPC, the mere filing of the complaint interrupts the running of the prescriptive period, okay? With the exception of those cases that are governed by summary procedure. Sa summary procedure, it's important that there is already a filing of the information with the court, okay? In order for it to interrupt the running of the prescriptive period. I hope you get that, okay? Unya, in the case of Panagiton versus DOJ, the issue raised was whether or not the filing of the complaint for violation of BP 22 before the office of the prosecutor interrupts the running of the prescriptive period for the offense. And the court ruled that the Act number 3326 applies to offenses under BP bilang 2022. An offense under BP bilang 2022 merits the penalty of imprisonment of not less than 30 days but not more than 1 year or a fine. Hence, under Act number 3326, a violation of the BP bilang 22 prescribes in 4 years from the commission of the offense or if the same be not known at the time from the discovery thereof. Nevertheless, we cannot uphold the position that only the filing of the case in court can toll the running of the prescriptive period. So, giklaro gyud ni sa Supreme Court na when it comes to the distinction between violations of special penal laws such as that of BP bilang 22, the mere filing of the complaint already interrupts or tolls the running of the prescriptive period. Okay. The court also explained that when Act number 3326 was passed, the preliminary investigation could be conducted by the justices of peace. Thus, the phraseology in the law institution of judicial proceedings for its investigation and punishment. The court also ruled and so held that the offense has not yet prescribed, in this case in Panagiton versus DOJ. The petitioner's filing of his complaint affidavit before the office of the city prosecutor signified the commencement of the proceedings for the prosecution of the accused and thus effectively interrupted the prescriptive period for the offenses they had been charged under BP bilang 2022. There's also a significant pronouncement which confirms the rule that the filing of the complaint for purposes of preliminary investigation interrupts the period of prescription of criminal responsibility. It was likewise made in several cases, such as that of Sanrio, Panagiton, and the earlier case katong sa Intellectual Property Code violation. And then, according to the Supreme Court, in this case of People versus Pangilinan, there is no more distinction between cases under the RPC and those covered by special laws with respect to the interruption of the period of prescription. Okay? The ruling daw in the case of Saldivia versus Reyes Jr. is not controlling in special laws. Okay? According to the Supreme Court, in Lienes versus Dikdikan, the court held that the institution of proceedings for preliminary investigation against the accused interrupts the period of prescription. Okay? Also, in the case of SEC versus Interport Resources Corporation, the Supreme Court ruled that investigations conducted by the SEC for violations of the Revised Securities Act and the Securities Regulations Code effectively interrupts the running of the prescriptive period because it is equivalent to the preliminary investigation conducted by the DOJ in criminal cases. Okay? In fact, according to the Supreme Court, in the case of Panagiton versus DOJ, which is all fours with the instant case, this court categorically ruled that commencement of the proceedings for the prosecution of the accused before the office of the city prosecutor effectively interrupted the prescriptive period for offenses they had been charged under BP Bilang 22. Okay? In order to have a better appreciation of these cases, I suggest that you read the full text para mas ma-appreciate ninyong mga kasuhan eh. And then also in the case of Dicini versus Sandiganbayan, ningon ng Supreme Court, even the filing of the criminal complaints in the office of the Ombudsman, even in the office of the Ombudsman, it effectively interrupts the running of the prescriptive period. Okay? The prevailing rule is therefore that irrespective of whether the offense charge is punishable by the RPC or by a special law, it is the filing of the complaint or information in the office of the public prosecutor for purposes of preliminary investigation that interrupts the period of prescription. Okay? Unya, di man ipod na even if the court does not have jurisdiction over a particular case, kung na-file anang kortiha, it interrupts the running of the prescriptive period. Okay? The running of the period of prescription is interrupted when the filing of the action, even in court in which the action was first filed, is without a jurisdiction. Bisan pag nasayop kag file o korte, it also interrupts the running of the prescriptive period. Okay? Also, in People versus Galano, citing previous pronouncements, the court instructed that an information was filed with Batangas Regional Trial Court, even though the evidence of both the prosecution and defense shows that the crime was committed in Manila. This court, the Supreme Court, in applying the case of People versus Olarte, held that it was only when the trial court dismissed the case due to lack of jurisdiction that the proceedings therein terminated without conviction and acquittal. And it was only then that the prescriptive period, which was interrupted during the pendency of the case in Batangas Court, commenced to run again. I'm not sure if you can already visualize, but this is how you should actually think of the concept of prescription. If let's say the offense was committed, like katong kaganiha, example lang, the offense was committed in 2015, example 2015, okay? And the penalty imposed by law is, let's say, reclusion perpetua. Reclusion perpetua. Kung reclusion perpetua, pila ganito ang unsa gito'y period sa prescription kung reclusion perpetua?
20 years.
20 years. Okay? So the offense was committed in 2015. Example, January 30, 2015. Okay? January 30, 2015. The case was filed in January 30, 2016. Okay? The crime was committed, let's say, in Cebu City, but the case was filed in Naga City. Okay? The case was filed in Naga City in January 30, 2016. So, ning take cognizance ang Naga for a period of 2 years until it realized nga, ay, waman na ko jurisdiction aning kasuha. So, I will have to dismiss this case. So, gidismiss ni Naga City, RTC, ang kaso against, let's say, Pablito. In January 30, pila naman to? 2016 plus 2 years, 2018. Okay? January 30, 2018. Okay? Karon, pila naman lang ang nahabilin nga tuig ni offended party in this case nga pwede siyang mo-file og kaso against Pablito. Pila na lang nahabilin niya nga tuig?
18?
I don't think the
19 because the 2 years is not included.
the 2 years is not included with the
17.
Yes.
yeah.
Yes. Mao na ipasabot ane. Mao na ipasabot ane ha nga the running of the period of prescription is interrupted with the filing of the action even if the court in which the action was filed is without jurisdiction. So in the earlier example nga kung gisayt, even if ning run na ang 2 years from 2016 to 2018, dili pwedeng moingon si offended party nga appeal na siya sa pagdagan sa prescriptive period because the moment it was filed in Naga City na interrupted na even if si Naga City RTC did not have jurisdiction to actually try the case filed against Pablito. Okay? So ang remaining number of years pa ni offended party in this case to file the case against Pablito is pila? Pila ka years?
19 years.
19 years.
Attorney.
Yes, very good. Okay. Also, in the case of People versus Enrile, niingon ang Supreme Court, informations were filed against civilians before military tribunals which had no jurisdiction over the persons of these civilians. These civilians questioned the refiling of the cases against them before the civil courts, raising among others that the crimes for which they are being charged have already prescribed. This court threw out the defense of the prescription and held that the filing of the first indictments suspended the running of the prescriptive period, and the prosecutions under the informations to be filed should be regarded as mere continuations of the previous proceedings. At the very least, naingon na Supreme Court, the filing of the first charges shall be considered as having interrupted the prescriptive period, notwithstanding the lack of jurisdiction of the military tribunal in which they were filed. Okay? I hope klaro na ang concept on prescription and when it is interrupted. Okay? Now let's go to Section 2 and Section 3. Let's read together Sections 2 and 3 of Rule 110. Section 2 provides that the complaint or information shall be in writing in the name of the people of the Philippines, okay? In the name of the people of the Philippines and against all persons who appear to be responsible for the offenses involved. Now, unsam din ang complaint? Ang complaint, according to Section 3, is a sworn written statement. Pwede rin ninyong i-memorize. It's a sworn written statement charging a person with an offense. Okay? Sworn written statement charging a person with an offense. I-chargean nimo ang usa ka tawo og offense subscribed by the pwede ani bisag kinsa, by the offended party, ang biktima, by any peace officer, okay, kanang mga police, or public officer charged with the enforcement of the law violated. Example, you violate customs laws, okay? This may be subscribed by the lawyers or the public officers charged with the enforcement of the customs laws. Let's say you violated the NIRC or the National Internal Revenue Code. Ang complaint ana against violation of the NIRC may be subscribed by the public officer charged with the enforcement of the NRC. Okay? Mura ni siya. Either tulo na hap ang pwede mo subscribe, offended party, peace officer, or public officer charged with the enforcement of the law violated. Okay? Timan-ing ang complaint is not a mere statement. And karon, because of the advent of the judicial affidavit rule, ang complaint karon must be in the form of judicial affidavit. Complaint-judicial affidavit. Okay? It is a statement charging a person with an offense. Unya, klaro sa dire sa inyong section 3 na it must be sworn and it must be written. Unsa nang sworn? Dapat imong panumpaan, moatubang ka og usa ka person nga authorized to administer oaths. So, ang kaning complaint kasagaran ang mo-sworn ani kay ang mga prosecutors or ang piskal. Okay? Be it noted too that the complaint is subscribed only by any of the persons specified in this rule, in this section, section 3. Sama sa gingon ang offended party, ang peace officer, karon mo ni sila ang mga police officers, or mga public officers charged with enforcement of the law violated. As I mentioned earlier, pwede, let's say, naka-violate kag customs laws, naka-violate kag BIR laws, mga environmental laws. Kung kinsa ang officer charged with the enforcement of the law violated, they will be the one to subscribe the complaint against a particular perpetrator or offender. Okay? So, karon, the question would be, in whose name man and against whom a complaint is to be filed. Okay? Giklaro na dire na the complaint is actually not filed in the name of the private person, ha? It should be in the name of the people of the Philippines. Nya, against whom man i-file? It should be against all persons who appear to be responsible for the offense involved. So kung 1 or 2 or 3 ang persons involved in the offense charge, kailangan ibutang gina ninyo ang pangan-anang mga tawhana. Okay? Remember also that in criminal cases, ang interest ra gyud sa private complainant or sa private offended party is limited only to the civil liability. Okay? Diba? It has been ruled that in prosecution of offenses, the complainant's role is limited to that of the witness for the prosecution. Okay? So if ang criminal case ma-dismiss or there's an acquittal, ang appeal nga pagabuhaton ana on the criminal aspect may be undertaken only by the state. And this should be through the Solicitor General. And the offended party here, the private offended party, may not take such appeal because only the Solgen may actually represent the people of the Philippines. However, the offended party may appeal the civil aspect of the case, even if the accused is acquitted in the criminal case. Mo nagiingon sa Supreme Court in the case of Ong versus Henyo. Unsa din nahitabo aning Ong versus Henyo? Ato yung tan-aon. In this case, si petitioner Elvera Ong, the petitioner for brevity, filed a criminal complaint against the respondent Jose Casim Henyo, or the respondent, for robbery. Okay? Kaning kasuha was actually dismissed by the city prosecutor of Makati City. However, pursuant to the resolutions subsequently issued later on, dated September 15 and October 30, 2006 of the DOJ, kay ni-apilar man ang petitioner, the respondent was charged with the crime of robbery in an information which reads that in or about and sometime the month of January 2003 in the city of Makati, Philippines, and within the jurisdiction of this honorable court, the above named accused did then and there willfully, unlawfully, and feloniously take, divest, and carry away kitchen and canteen equipment as well as her personal things valued at 700,000 pesos belonging to the complainant Elvira Ong to the damage and prejudice of the said honor in the aforementioned amount of 700,000 pesos contrary to law. So mauni ang content sa information, okay? Karon, pag November 21, 2006, si respondent kato si Henyo, patong respondent Jose, filed a motion to dismiss the case for lack of probable cause pursuant to Section 6, Paragraph A of Rule 112 of the Rules of Court, and in view of compelling grounds for dismissal of the case to hold in abeyance the issuance of the warrant of arrest. Si Petitioner Elvira in this case filed an opposition dated December 11, 2006 to the respondent's motion to dismiss. Unya, nipagawas og order ang RTC Makati dismissing the case because according to RTC Makati, the other elements of the crime of robbery, specifically the elements of intent to gain and either violence against or intimidation of any person or force upon things were not specifically alleged in the information filed against the respondent. Okay? Despite sa dismissal, si respondent filed a partial motion for reconsideration, reiterating that the information should be dismissed in its entirety for lack of probable cause. So ni-oppose na pod ni Ron, si Petitioner Elvira. So ni-order na pod ang RTC, granting respondent's partial motion for reconsideration and indeed dismiss the case for lack of probable cause. Okay? So, ngayon ng RTC nga ang evidence on record failed to establish probable cause to charge respondent with the crime of robbery. Moto nga pag March 6, 2007, si Elvira filed now a motion for reconsideration claiming that ang RTC nasayop in saying that Section 6, Paragraph A, Rule 112 of the Revised Rules on Criminal Procedure, since the said provision relates to issuance of warrant of arrest, and it does not cover the determination of probable cause for the filing of information against the respondent, which is executive kuno in nature and a power primarily vested with the public prosecutor. So ni-order na pod ang RTC. Gideny sa RTC ang motion nga gi-file ni Elvira for this case, holding that the affirmation provision authorizes the RTC to evaluate not only the resolution of the prosecutor who conducted the preliminary investigation and eventually filed the information in court, but also ang evidence upon which the resolution was based. And in the event that, according to the RTC, in the event that the evidence on record clearly fails to establish probable cause, the RTC may dismiss the case. So naagrabyar na pod si petitioner in this case, naabot na siya og Court of Appeals, okay? And then sa Court of Appeals, ningon ng Court of Appeals nga the people of the Philippines was impleaded as petitioner without showing, however, that the Office of the Solicitor General participated in this appeal, okay? So ang gibuhat sa Court of Appeals, it ordered Elvira to furnish the Office of the Solicitor General with a copy of the petition. And it also ordered the Office of the Solicitor General to make a comment on the petition. So karon, si Office of the Solicitor General, si OSG, filed its comment, taking the stand of the respondent that only the Solicitor General kuno can bring or defend actions on behalf of the people of the Philippines filed before the CA or the Supreme Court. Okay? The OSG submitted that for being fatally defective, the petition should be dismissed insofar as the criminal aspect was concerned, without prejudice to the right of the petitioner to pursue the civil aspect of the case. So pag 2008, January, ang Court of Appeals rendered a resolution dismissing the case. Gidismiss gyud ang kaso nga gifile ni Elvira, but without prejudice to the filing of a petition on the civil aspect thereon on the basis of the arguments raised by both the respondent and the Office of the Solicitor General. So undaunted, si Elvira now filed a motion for reconsideration with the CA, and the CA also denied the same in a resolution dated March 28, 2008. So motong nabot siya sa Supreme Court. And in the Supreme Court, the issue here is whether or not the petitioner, as the private offended party in a criminal case, has no personality to elevate the case to the Court of Appeals without the conformity of the Office of the Solicitor General, even before the accused is arraigned. Okay? So niingon ang Supreme Court, this instant petition is bereft of merit. Okay, Section 35, Paragraph 1, Chapter 12, Title 3 of the Administrative Code states that the OSG shall represent the government of the Philippines, its agencies and instrumentalities, and its officials and agents in any litigation, proceedings, investigations, and matter requiring the services of lawyers. Likewise, the Solicitor General shall represent the government in the Supreme Court and in the Court of Appeals in all criminal proceedings. Thus, specifically in Section 31, niingon ko dito nga, the Office of the Solicitor General shall represent the government of the Philippines, its agencies and instrumentalities, and its officials and agents in any litigation, proceedings, investigation, or matter requiring the services of lawyers. And when authorized by the President or head of office concerned, it shall also represent government-owned or controlled corporations. The Office of the Solicitor General shall constitute the law office of the government, okay? And as such, shall discharge duties requiring the services of lawyers. It shall have the following specific functions. I-enumerate pa yun sa Supreme Court. Represent the government in the Supreme Court and the Court of Appeals in all criminal proceedings. Timan-ig yun ninyo ha, because in your practice later on, you will realize that kung ikaw ang private prosecutor, you need to have the authority from the OSG in order for you to elevate your case to the Court of Appeals, okay? Represent the government and its officers in the Supreme Court, the CA, and all other courts or tribunals in all civil actions and special proceedings in which the government or any officer thereof in his official capacity is a party. And then this doctrine is laid down in the ruling of the Supreme Court in the case of heirs of Federico Delgado versus Gonzalez et al., where the Supreme Court held that only the OSG can bring or defend actions on behalf of the Republic or represent the people or state in criminal proceedings pending in the Supreme Court and in the Court of Appeals. And ningon ng Supreme Court, while there may be rare occasions when the offended party may be allowed to pursue the criminal action on his own behalf, as when there is a denial of due process, this exceptional circumstance does not obtain in the instant case. Okay? Dili daw na mao ang nahitabo aning kasuha. Before the Court of Appeals, the Office of the Solicitor General itself opined that the petition therein was fatally defective for having been filed without the OSG's participation. And before the Supreme Court, the petitioner failed to advance any justification or excuse why she failed to seek the assistance of the OSG when she sought relief from the Court of Appeals, other than the personal belief that the OSG was burdened with so many cases. Thus, niingon ng Supreme Court, we find no reversible error to disturb the CA's ruling. But, niingon ng Supreme Court, however, However, ang petitioner in this case is not without any recourse. Okay? Wala, napay paglaom si petitioner in this case. Ningon na Supreme Court, in one case, in Rodriguez versus Gadiani, niingon me nga it is well settled that in criminal cases where the offended party is the state, the interest of the private complainant or the private offended party is limited to the civil liability. Thus, in the prosecution of the offense, the complainant's role is limited to that of the witness of the prosecution or for the prosecution. Now, if a criminal case is dismissed by the trial court, or if there is an acquittal, an appeal therefrom on the criminal aspect may be undertaken only by the state through the Solicitor General. Okay? Only the Solicitor General may represent the people of the Philippines on appeal. The private offended party or complainant may not take such appeal. However, ngayon ng Supreme Court, however, the said offended party or complainant may appeal the civil aspect despite the acquittal of the accused. Okay? And a special civil action for certiorari, it is alleged that the trial court committed a grave abuse of discretion amounting to lack of jurisdiction or on other jurisdictional grounds. The rules state that the petition may be filed by the person aggrieved, and in such case, the aggrieved parties are the state and the private offended party or the complainant. So the complainant here has an interest in civil aspect of the case. So he may file such special civil action questioning the decision or action of the respondent court on jurisdictional grounds. And in so doing, the complainant should not bring the action in the name of the Philippines. The action may be prosecuted in the name of the said complainant. Okay? So on this ground alone, ngayon na Supreme Court, katong gifile ni Elvira, already fails because what she did is she instituted the case in the name of the people of the Philippines, but siya ang nirepresentar sa people of the Philippines. When in fact, what she should do is only to file an appeal with respect to the civil aspect of the case and use her own name to that effect and file the case for certiorari. In that case, manggod, ni-appealar siya and then i-file siya certiorari, but questioning the jurisdiction or questioning the decision of the CA, but in the name of the people of the Philippines, which should not be the case because when we talk about criminal appeals or appeals before the CA and the Supreme Court, this should be done by the office of the Solicitor General and not by the private offended party. I hope na klaro na. Okay? At giklaro sad nga kung civil aspect lang ang iyahang gireklamo, it can be done and it can be questioned, but it should be in her name, under her name, and not in the name of the people of the Philippines. Okay. Now we know the concept of complaint. Before we proceed to information, let's have a break first. Let's have a 7-minute break. Let's be back at 6:50. Okay, let's now proceed to information. That's section 4 of your Rule 110 of the revised rules on criminal procedure. According to section 4, an information is an accusation in writing charging a person with an offense subscribed by the prosecutor and filed with the court. If you remember the definition of complaint, niingon tanong nga, a complaint is an accusation in writing. It's a sworn written statement charging a person of an offense and subscribed by the offended party, diba? Charging a person of offense, subscribed by the offended party, any peace officer or public officer charged with the enforcement of the law violated. But in the information, it's very short, it's different because here, it's already an accusation in writing charging a person with an offense. Unya ang mo subscribe ra ani kay ang prosecutor, unya mauna ni siya ang i-file ngadto sa court. Okay? Mauna ang information. Later on, I'll show you what an information looks like. No? So, while an information is an accusation in writing, it is not required to be sworn, unlike a complaint. Because in this case, ang mo subscribe raman ani kay ang prosecutor, meaning iyan ang pirmahan, okay? Pirmahan ni piskal. And like a complaint, an information is filed in the name of the people of the Philippines, okay? People of the Philippines against all persons who appear to be responsible for the offense involved, okay? And then you have to take note also that criminal prosecutions primarily revolve around proving beyond reasonable doubt the existence of the elements of the crime charged. So, since ang conviction or ang acquittal in a criminal case primarily hinged on the proof that the overt acts constituting or the elements of the crime were indeed committed or are present, ang allegations in the complaint or in the information are crucial to the success or failure of the criminal prosecution. Mo na nga kailangan nga ang information kompleto ang mabutang diha. It is for this reason that the information is considered the battleground in criminal prosecutions. Now, how do we distinguish man di ay a complaint and information? A complaint must be sworn, okay? Hence, it has to be under oath by the clear terms of Section 3, Rule 110. Because, di ba, dito, it is a sworn written statement charging a person an offense, subscribed by the offended party, etc., etc. While an information requires no oath. In Section 4 of Rule 110, atong gitanaw earlier in the previous slide, it merely requires that it be an accusation in writing. Okay? This is because the prosecutor filing the information is already acting under the oath of his office. Okay? And then another distinction, a complaint is subscribed by, diba, to enumerate kaniha, offended party, peace officer, or public officer charged with the enforcement of the law violated. While ang information is subscribed only by the prosecutor. Okay? Note, guys, that if the original information was signed and filed by one who had no authority to sign and file the same, the dismissal of the information would not be a bar to a subsequent prosecution under a subsequent valid information. Okay? Pwede rin yun ma-refile with the correct authority na to sign and file the same. Now, kanus ang makaingon nga complaint or information is deemed sufficient. Okay? A complaint or information is deemed sufficient if it contains the following. Kani. The name of the accused, pangan sa akusado, and if the offense is committed by more than one person, all of them shall be included in the complaint or information. Okay? Dayon the designation of the offense given by the statute, and then the acts or omissions complained of as constituting the offense, and then the name of the offended party, and then the approximate date of the commission of the offense, and the place where the offense was committed. Okay? For an information to be sufficient, it must validly charge an offense. Whether an information validly charges an offense depends on whether the material facts alleged in the complaint or information will establish the essential elements of the offense charged. In other words, in criminal prosecution, diman-anin nyo nga every element constituting the offense must be alleged in the information before ang akusado makonbikto sa offense nga gi-charge sa iyaha. Okay? Ang purpose ani is for the accused to be able to suitably prepare for his defense because, di ba, he is presumed to have no independent knowledge of the facts that constitute the offense. Take for example ha kanang case or crime of rape, di ba? I'll show you later an information to one of my cases. It's actually rape, so akong ihatag sa iyo sa background. Ang rape under Article 266-A, it will be committed by a man who shall have carnal knowledge of a woman under any of the following circumstances: through force, threat, or intimidation, when the offended party is deprived of reason or otherwise unconscious, by means of fraudulent machination or grave abuse of authority, or when the offended party is under 12 years old or demented, even though none of the circumstances mentioned be present. Now, taking into consideration the elements of rape, when you prepare an information, kailangan ka na nga mga elements makita na sa information, okay? I'll show you an example of an information which, maklaro ba? Akong gipang redact ang uban nga mga details. Ang accused ani, tulo ka buok. One of the accused is my client. This is a case for rape filed before the RTC of Mandawi City, okay? Now, this is the caption of the case, kane? And then this is the body of the information. So the information here states that the undersigned, pasabot si prosecutor, okay? The undersigned accuses A, B, C of the crime of rape committed as follows: that on the 26th day of March 2017, kita mo, it's the date of the commission, di ba? At around 4 o'clock in the morning, at Barangay Yati, place of the commission of the crime, and within the jurisdiction of the Honorable Court, the above name accused, or the name of the accused, na apo dire, with lewd designs and by means of force and intimidation, did and there willfully and lawfully and feloniously lie and succeed in having carnal knowledge with one X, or this is the name now of the offended party, against her will and without her consent, while the accused A, B, and C conspired and mutually helped the above named accused and one another by holding the hands of the victim. So if you can see, klaro dire nga ang atoang gi-require name of the accused, na kung daghan sila, ibutang tanan, designation of the offense, the acts or omission complained of, the name of the offended party, the approximate date of the commission of the offense, and the place where the offense was committed, present in the information, okay? So when preparing an information, kailangan kato siyang mga factors that you need to consider must be attendant in the preparation of the information. And this is how it looks like. Muna iyahang isubscribe by the prosecutor. I-subscribe niya. And then there's a certification here also by the prosecutor. And then, subscribe and sorted before me. So, muna sila ang mga prosecutors nga ning subscribe or ning approve sa recommendation sa fiscal to file the case of rape against the 3 accused. Okay? So, yun ani ang now sa information. Nakat lang na ko siya kaigo in one screen. Okay? Timan guys, nga the nature of the criminal charge is determined by the recital of the ultimate facts and circumstances in the complaint or information and not by the caption. Okay? Dili base lang sa caption nga rape, okay? It is based on these, recital of the facts and circumstances, okay? In other words, the facts alleged in the body of the information, not the technical name given by the prosecutor, will determine the character of the crime, okay? Now on to Manata Section 4. Let's go to Section 5 of Rule 110. Exhaustive ning Section 5. So may I ask a volunteer to read this one? Anyone? Kasi pwedeng mo basa sa Section 5. Magighawa sa ko guys. Gamay. Any volunteer to read Section 5?
Okay, attorney here.
Akim. Sige, Akim. Go.
Who must prosecute criminal action? All criminal actions, either commenced by complaint or by information, shall be prosecuted under the direction and control of a public prosecutor. In case of heavy work schedule of the public prosecutor, or in the event of lack of public prosecutors, the private prosecutor may be authorized in writing by the chief of the prosecution office or the regional state prosecutor to prosecute the case subject to the approval of the court. Once so authorized to prosecute a criminal action, the private prosecutor shall continue to prosecute the case up to end of the trial, even in the absence of a public prosecutor, unless the authority is revoked or otherwise withdrawn. As amended by AM number 02.
Yes, as amended by AM number 02-2-07-SC, and this took effect on May 1, 2000. Next paragraph.
The crimes of adultery and concubinage shall not be prosecuted except upon a complaint filed by the offended spouse. The offended party cannot institute criminal prosecution without including the guilty parties, if both alive, nor in any case, if the offended party has consented to the offense or pardoned the offenders. Second, the offenses of seduction, abduction, and acts of lasciviousness shall not be prosecuted except upon a complaint filed by the offended party or her parents, grandparents, or guardian, nor in any case if the offender has been expressly pardoned by any of them. If the offended party dies or becomes incapacitated before she can file the complaint, and she has no known parents, grandparents, or guardian, the state shall initiate the criminal action in her behalf. Third, the offended party, even if a minor, has the right to initiate the prosecution of the offenses of seduction, abduction, and acts of lasciviousness, independently of her parents, grandparents, or guardian, unless she is incompetent or incapable of doing so. Where the offended party who is minor fails to file the complaint, her parents, grandparents, or guardian may file the same. The right to file the action granted to parents, grandparents, or guardians shall be exclusive of all other persons and shall be exercised successively in the order herein provided, except as stated in the preceding paragraph. No criminal action for defamation, which consists in the imputation of the offenses mentioned above, shall be brought except at the instance of and upon complaint filed by the offended party. 5A. Last, the prosecution for violation of special law shall be governed by the provisions thereof. And
last, this one.
okay.
Section 16. Please.
Section 16, intervention of the offended party in criminal action. Where the civil action for recovery of civil liability is instituted in the criminal action pursuant to Rule 111, the offended party may intervene by counsel in the prosecution of the offense. 16A.
Thank you, Akim. Okay. Remember, guys, that a criminal action, as per Section 5 of Rule 110, is prosecuted under the direction and control of the public prosecutor. Okay, this is the general rule, and this also applies to a criminal action commenced either by a complaint or information. Now, even if there is a private prosecutor, the criminal action is still prosecuted under the direction and control of the public prosecutor. Muna nga, in court, bitaw, when we appear, when we are given the authority. Example, aniha, you file a case for rape. X files a case for rape. This is a case in the name of the people of the Philippines. And as a general rule, the one who should prosecute the case is the public prosecutor, diba? So now, if the offended party wants to hire a private lawyer, the private lawyer now would become a private prosecutor if he or she is given a written authority by the public prosecutor's office. Okay? And when the said private lawyer appears before the court, ang iyang isultihan na dito would be, good morning, Your Honor, or good afternoon, Your Honor. Let's say, Attorney Velasco, respectfully appearing for the private complainant as private prosecutor under the direct control and supervision of the public prosecutor. So, specify yun na that your appearance there is under the direct control and supervision of the private prosecutor. Okay? A private party does not have the legal personality to prosecute the criminal aspect of the case. Nga naman, kay ang, as I've said, ang people of the Philippines man, ang real party in interest when it comes to criminal cases. Okay? The rationale, according to Chua versus Padillo, is that all criminal actions shall be prosecuted under the direction and control of the public prosecutor because the criminal offense is an outrage against the sovereignty of the state. So it necessarily...
Attorney, you're cutting off.
Oh, sorry. Balik. Hello, Akim, can you still hear me?
Yeah, we can hear you now. But you were cutting off a while ago, so.
Sorry. According to the case of Chua versus Padillo, the rationale for the rule that all criminal actions shall be prosecuted under the direction and control of the public prosecutor is that since a criminal offense now is an outrage against the sovereignty of the state, so it necessarily follows that a representative of the state shall direct and control the prosecution thereof. So the rule is also founded on the theory that a crime is a breach of security and peace of the people at large. That's why kung naagani criminal actions, it has to be under the direct and control of the public prosecutor. The public prosecutor being the lawyers of the state. Okay? There's actually a case which illustrates clearly the consequences of the rule that the prosecution of a crime is under the direction and control of the public prosecutor. This is the case of Pinute versus Aiko. Okay, this is actually an administrative matter, a case that is filed against a judge. In this case, a trial judge actually allowed the defense to present evidence consisting of the testimony of two witnesses, even in the absence of the prosecutor charged with prosecuting the case. So, ang prosecutor dire, at the time of the presentation of the testimony of the two witnesses was actually undergoing a medical treatment at a certain hospital in Quezon City. So maintaining that the proceedings conducted in his absence were actually void, the prosecutor on the subsequent hearings of the case refused to cross-examine the two defense witnesses despite being ordered by the judge. Okay? Bisang ina siya ni judge, i-cross-examine na piskal, ingon siya, di ko mo cross-examine because when it was presented, wala ko. So after manifesting to court the reason for his absence, a reason earlier relayed to the court on the day of the hearing in question,
Hello?
Shopee si attorney is
Nawala
really
si
arapo.
attorney, no?
Yeah, wait.
Nawala siya.
Dako nga portion atong statement na wala.
wala jud ko.
Dara, balik ka kasi pero ganihan na wala jud ka.
Okay. Nagamit ra mo ko kay nagdata ra ko kay ang PLDT diri sa amoa kay walay walay signal. Anyway, asa ko kutob ato Akim.
Wala ko nakapita siya.
Wala jud may kakuha na ning case ni Pinute versus Aiko nga.
Hindi natuwa sa computer.
Sugot siguro, attorney.
Nawala ka sa
Ang entire gid nimo nga discussion wala gid mi kadungog.
I think sa kuan attorney katong pag-present sa two witness.
Okay. Okay.
Without...
Ang natabo man gud ani. Okay, thank you guys. Ang natabo aning sa Pinute versus Aiko, this is actually a case filed against a trial judge. Okay? So ang judge man gud diri giallow niya ang defense counsel to present evidence consisting of the testimony of two witnesses sa akusado, bisag wala ang prosecutor charged with prosecuting the case. Okay? Kay nganong absent ang prosecutor atong time was because he was undergoing a medical treatment at a hospital in Quezon City. Now, si Fiscal maintaining nga ang proceedings conducted during his absence were void, on the subsequent hearings, ning refuse siya to conduct the cross-examination on the two defense witnesses. Bisan pag gisugo siya ni judge in this case. After manifesting to the court the reason for his absence, iya mo putong giingnan ng court nganong wala siya atong time during the presentation of the two witnesses, he reiterated his position that the act of the judge of allowing the defense to present evidence in his absence was erroneous and highly irregular. So he prayed that he should not be coerced to cross-examine those two defense witnesses and that their testimonies be stricken off the record. The judge in this case, nevertheless, considered the prosecution to have waived its right to cross-examine the two defense witnesses. So ning proceed gyud si judge bisan pa man og wala ning cross-examine si fiscal. Ang gihimong judge, okay, fiscal, if you will not cross-examine, you are deemed to have waived your right to cross-examine the two defense witnesses. So ang gihimo ni fiscal ron, ning file siya administrative complaint against the judge for gross ignorance of the law, grave abuse of authority, and serious misconduct. Okay? So, on the evaluation of the case, ang Office of the Court Administrator, mao man na ang mo review sa mga administrative matters no nga i-file before them, found the respondent judge to have breached the said rule and accordingly recommended that he be reprimanded with a warning that a repetition of the same or similar act should be dealt with more severely. According to the Supreme Court, adopting the findings of the Office of the Court Administrator, the court ruled that a violation of criminal laws is an affront to the people of the Philippines as a whole and not merely to the person directly prejudiced, he being merely the complaining witness. So it is on this account, held by the Supreme Court, that the presence of a public prosecutor in the trial of criminal cases is necessary to protect the vital interests, foremost of which is its interest to vindicate the rule of law, the bedrock of peace of the people. So ningon pag ang Supreme Court nga the act of allowing the presentation of the defense witnesses in the absence of complainant public prosecutor or a private prosecutor designated for that purpose is a clear transgression of the rules, which could not be rectified by subsequently giving the prosecution a chance to cross-examine the witnesses. So di gud pwede na si judge would proceed in hearing the testimonies presented by the accused if in this case ang nirepresentar ang public prosecutor o niya wala si public prosecutor. Muna nga if you are familiar or if you're working with the court, you will notice nga mo reset gina si judge kung may criminal cases o niya wala si fiscal. Kay under the rules required na nga criminal actions should be under the direct supervision and control of the public prosecutor. Okay? Now, in the case of Duca or People versus Duca, ningon po ng Supreme Court nga it is wrong for petitioners to argue that it is the OSG which has authority to file an appeal with the RTC. Section 35, Chapter 12 of the Executive Order Number 292, otherwise known as Administrative Code of 1987, mandates the OSG to represent the government in the Supreme Court and in the Court of Appeals in all criminal proceedings. On the other hand, ang Section 11 of the Presidential Decree 1275 entitled Reorganizing the Prosecution Staff of the Department of Justice and the Offices of the Provincial and City Fiscals, nag-ingon nga the provincial or the city fiscal, now referred to as prosecutors, shall have charge of the prosecution of all crimes, misdemeanors, and violations of city or municipal ordinances in the city of such province or city, and shall therein discharge all the duties incident to the institution of criminal prosecutions. Now, in consonance with the above quoted provision, it has been held by the Supreme Court that the fiscal or the prosecutor represents the people of the Philippines in the prosecution of offenses before the trial courts, at the metropolitan trial courts, the municipal trial courts, the municipal circuit trial courts, and the regional trial courts. And then, since the appeal in the instant case was made with the RTC of the Manila, it is clear that the city prosecutor or his assistant, in this case, the assistant city prosecutor, had the authority to file the same. We have cleared this earlier na required si OSG kung adto ka mo file sa CA o sa Supreme Court. But in the trial court such as MTC and RTC, ang mo representar sa state diha would be the prosecutors. Okay? Okay. Also remember that the rule on the appearance of the Solgen representing people of the Philippines on appeal or certiorari before the Supreme Court or Court of Appeals in all criminal proceedings is only a general rule, okay? There's actually an exception to this particular rule. And the exception is that cases elevated to the Sandiganbayan and from the Sandiganbayan to the Supreme Court. In this case, ang Office of the Ombudsman, through its special prosecutor, may or shall represent the people of the Philippines, okay? Except in cases filed pursuant to Executive Order number 1, 2, 14, and 14A issued on 1986, okay? Again, in all cases elevated to the Sandiganbayan and from the Sandiganbayan to the Supreme Court, the Office of the Ombudsman, through its special prosecutor, shall represent the people of the Philippines. Except kaning mga EO numbers 1, 2, 14, and 14. Unsa man ni sila? Kaning EO number 1, 2, 14, issued in 1986, katuning mga executive orders issued during the time of Cory Aquino for the recovery and sequestration of the Marcos wealth. And then kaning EO number 14A is the executive order creating the Presidential Commission on Good Government. So kani in these cases, this should be done by the OSG. But kung i-elevate sa Sandiganbayan and from Sandiganbayan to the SC, ang ombudsman ana ang mo representar sa state through its special prosecutor. Okay? Okay. When can a private prosecutor prosecute a case even in the absence of the public prosecutor? The rule is clear, especially in Section 5, Rule 110 of the Rules of Court. Ngayon dito, nga a private prosecutor may prosecute a criminal action up to the end of trial, even in the absence of the public prosecutor, if he is authorized to do so in writing. Okay? This written authorization shall be given by either the chief of the prosecution office or the regional state prosecutor. And then the written authorization, in order to be given effect, must however be approved by the court. Okay? So ang buhaton ana in the practice is that when the private offended party moduol sa imuha ganahan siya private lawyer, what you will do as the private lawyer is to obtain an authority, a written authority from the office of the prosecutor. Either it could be a provincial or a city prosecutor. So once tagaan na ka, ang tawag ana is authority to prosecute. Okay, ang tawag ana nga document. I just forgot to attach here sample authority to prosecute, but on the next meeting I'll show you the content of the authority to prosecute. But basically, when you're a private lawyer, you obtain that authority to prosecute from the prosecutor's office, and then once you have it, you need to submit it before the court and have it approved. So maghuwat ka sa order nga si judge approves the written authority to prosecute. Once you have it, you're good to go, okay? But it doesn't mean nga magbuot-buot na ka, you are still under the direct supervision and control of the public prosecutor, okay? The private prosecutor cannot, for just any reason, be authorized to prosecute the criminal case. Klaro in Section 5 ningon dito nga the written authorization to the private prosecutor shall be given because of either of the following reasons. Una, heavy workload sa public prosecutor, or there is lack of public prosecutors. Okay? So, maura na siya ang mahog or basis for which you will be given as a private lawyer, given an authority to prosecute the case on behalf of the public prosecutor. Okay?